And we're having agreed it by the both sides, matter. Item 28 maybe taken up on 27th of April to your lordship's convenience.
20,
8 item.
that license matter.
Hello?
Honda
Yes, yes.
workshop.
Yes, Your Lordship.
When?
27th April.
As agreed to by the learned counsel for the parties. The learned counsel for the parties have jointly prayed for an adjournment in the matter. Also, as agreed to by the learned counsel for the parties, a registry to list this matter again on when?
27th of April.
27th, 2026.
Oblige.
Oblige, Your Lordship.
May I please, Your Lordship? Item number 45 and 46 has been complied with, my lord.
You are W. Rahman.
W. Rahman, yes, my lord.
Mr. W. Rahman, learned counsel for the petitioner, and Mr. Borpujari is here.
Yes.
R. Borpujari, learned counsel, appearing for the respondent number 1. Mr. W. Rahman, learned counsel for the petitioner, submits that the directions, violation of which is alleged in the present contempt petition, has been since complied with by the respondent authorities, and accordingly he prays that the present contempt petition be closed. Prayer accepted. The present, in view of the submissions made by the learned counsel for the petitioner, that the directions involved have been complied with, the present contempt petitions is closed. Also, next, 46. Here, nobody is appearing for the respondents. But Mr. W. Rahman, respondent on Nalaga. Officer Likiti, same bostu. Same order. Yes.
Oblige.
May I please, Your Lordship? I beg to mention item number 11. This matter may kindly be adjourned for a day, Lordship, as the engaged counsel, B.C. Das has some personal difficulties.
On the prayer of, a prayer is made on behalf of Mr. P.C. Das, learned senior counsel.
Yes, Lordship.
Learned senior counsel for an adjournment in the matter on account of personal inconvenience. Prayer is not, have you taken the consent?
No, Lordship. I will take it later.
Prayer is not objected to by the learned counsel. In view of the above, registry to list this matter again after 2 weeks on a date to be fixed.
Lordship, kindly date may be fixed.
May I please, Your Lordship, with the consent of the respondent, I beg to mention item number 37. Lordship, in this matter, we have recently engaged. Lordship, I will file ukalatnama today itself,
They
Lordship.
have not filed an affidavit in this matter.
Yes, Lordship.
You be here, we will not pass any orders. You will just ask them to get the affidavit on record. Comment. That much only. Don't worry, not
Okay.
passing any order.
May it please, Your Lordship, I beg to mention item number 54, Lordship, connected with supplementary 58. Lordship, PK Roy has fever, Lordship.
Have you taken the consent of the other side? They are here.
Yes.
Then item number 1 is also one to connected question. Item number 54 and 58.
8.
Have you taken the consent? 54, 58. Huh? On the prayer, a prayer is made on behalf of Mr. P.K. Roy Chaudhary, learned counsel for the applicant in I bracketed civil 867/2020 and for the respondent number 7 in WPC number 5746/2025, with the consent of the learned counsel for the other side, for an adjournment in the matter on the ground that he is indisposed. Prayer accepted. Registry to list this matter again after
Next week, any date, Lordship?
a week on a date to be fixed by it.
May I please, Your Lordship? I beg to mention item number 12 of the list. We have taken consent from the respondent side, my lord. Yesterday, we have filed a adjournment slip, my lord, as the board.
They have not filed an affidavit also here. Why? You are appearing for
Lordship, respondent number 2 to 5, Your Lordship.
railways.
GST, Your Lordship.
The respondents are?
Lordship 2 to 5, CGST, Your Lordship.
No. You are the CGC.
I'm appearing on behalf of Mr. S.C. Kyal, Your Lordship, for CGST.
He is a CGSC, no?
Yes, Your Lordship.
Prayer is made on behalf of Mr. DJ Kapil, learned counsel for the petitioner for an adjournment in the matter on account of personal inconvenience. Prayer is not objected to by Miss
P. Upadhyay, Lordship.
P. Upadhyay, learned counsel appearing on behalf of Mr. S.C. Care, CGC, appearing for the respondents.
CGST, Your Lordship.
CGST, learned standing counsel, CGST. CST, Customs and Service Taxes.
Yes, Your Lordship.
CST, appearing for the respondents number 225. Also, Ms. Upadhyay submits that the affidavit on behalf of the respondents represented by her also be brought on record within
3 weeks, Your Lordship.
within a period of 3 weeks from today. In view of the above, registry matter stands adjourned today. Registry to list this matter again on 8/4/2026. The affidavit of the respondents be brought on record before the next date of.
May I please, Your Lordship? I beg to mention item number 4 with the consent of the other side. Matter may be taken up after 2 weeks, Lordship.
Lord Lordship, I am appearing for respondent 3 and 4, Lordship.
3 and 4. And for the petitioner on behalf of alia.
You are Seri.
Lordship. Here also, Lordship, we are required to file an affidavit, Lordship. I have already intimated, Lordship, the earlier or
Counsel, how is this case to be maintained here? You'll have to go before the appropriate forums. Because the COVID situation was there, this court had entertained, but that will not mean that we'll have to continue with this. What is the ground of seeking adjournment?
The learned counsel has some personal difficulty.
Who?
Alia. On behalf of the petition.
To file an affidavit, take
Lordship,
that plea.
Lordship, I will file, Lordship.
But Mr.
And Ghosh.
N. Ghosh, a prayer is made on behalf of Mr. A. Learned counsel for the petitioner for an adjournment in the matter on account of person. Prayer is not objected to by Mr. A. Bhattacharya, learned counsel appearing for the respondent number
3 and 4, Lordship.
3 and 4. Also, Mr. Bhattacharya submits that an affidavit on behalf of the respondents presented by him would be brought without fail would be brought on record invariably on or before
2 weeks time, Lordship, it will come from Calcutta, Lordship.
on or before 1/4/2026. Registry to list this matter again on 6/4/2020.
Much.
May I please, with the consent of the other side, I beg to mention item number 10, Your Lordship. Similar series of matter has been kept reserved for judgment by Honorable Coordinate Bench, Lordship. So this matter may kindly be taken up after 2 weeks, Lordship.
But here your plea is that the notice
Yes, Your Lordship.
as well as the order
Yes, Your Lordship.
in demand are all beyond the
Yes,
time.
Your Lordship. And
I have tried to go through it, but I don't find fraud or anything being alleged. So if that be so, how is the notice is sustainable? But only argue on that.
similar issue, Lordship. Judgment has been received.
On the a prayer is made on behalf of Ms. M.L. Gop, learned counsel for the petitioner for an adjournment in the matter on account of person in registry to list this matter again after 4 weeks on a date to fix by.
Interim may be continued, Lordship.
Interim order passed earlier to continue till the next date.
May it please Lordship, I beg to mention item number 26. As my senior is out of station, I kindly seek for adjournment.
You are making a prayer on behalf of?
Dr. B.N. Gogoi, GST.
Rejected. No affidavit. Why no affidavit from 24?
Lordship, I'm not aware of that,
You
Lordship.
need not be aware. We'll ask the respondents why the affidavit has not come on record. Yes,
May
come when the matter is called.
it please, Your Lordship? I beg to mention item number 8, Your Lordship. Kindly, yes, Your Lordship. Kindly pass over the matter for the day.
You are making this prayer on behalf of?
Mr. J. Firdaus.
Huh?
Mr. J. Firdaus.
Eh?
We are the J. Firdaus. We are the
So
petitioner.
what
my
is the error here, madam?
Your Lordship, we are newly engaged counsel, so some time may be given, Your Lordship.
They have brought on record their affidavit. They're in the complete confiscation proceedings is brought on record. You have not filed an affidavit. Reply. The proceeding that is there, that procedure has been completely followed. You were bringing,
1 week time.
why did you not circulate a mention memo yesterday? We had to spend time. Where is Mr. Firdaus?
He has some personal difficulty, Your Lordship.
He's not in
out of
court
station,
today.
Your Lordship.
Prayer is made on behalf of Mr. J.
My lord, my pleasure, lordship. We were engaged in this case. Our name may kindly be Dr. Arsi Patpatra, who was there. Our name.
You file an application before the registry, they'll do
We
it.
may be allowed to withdraw from the case.
You file an application. Prayer is made on behalf of Mr. J. Firdaus, a learned counsel for the petitioner, for an adjournment in the matter on account of personal inconvenience. Prayer accepted. Registry to list this matter again on 25/3/2026.
Obliged.
May I please? May I please, Lordship, with the consent of others said, Lordship, I beg to mention item number 55, Lordship. I am appearing before respondent number 6, Lordship. I will file affidavit, Lordship. I need some time, Lordship.
You
54
are
back.
appearing for
Respondent number 6,
H. Yasmin,
P. Udhikari.
Huh?
P. Udhikari.
P. Odikari. Ms. P. Odikari, learned counsel for the respondent number 6, prays that she be granted further. She be granted 2 weeks' time to file an affidavit on behalf of the affidavit in the matter on behalf of the respondent represented by them. Have you informed the petitioner?
Yes, Lordship.
The prayer is stated to have been made with the consent of the learned counsel for the petitioner. Registry, prayer accepted. Registry to list this matter after 2 weeks on a date to be fixed by it. The respondent number 6 shall invariably bring on record the affidavit as undertaken to be filed before the next date of list.
May it please your Lordship, with the consent of the other side, I beg to mention item number 22.
Appellate tribunal constituted. Want to what? Adjourn or withdraw?
Adjourned.
Has an appellate tribunal been constituted? Where is Mr. Goel?
He is not in town.
A prayer is made on behalf of Mr. A. Goel, learned counsel for the petitioner, on the for an adjournment in the matter on the ground that he is presently not in. Prayer is not objected to by the learned counsel for the respondent. Have you informed respondents? Also, registry to list this matter again after 2 weeks on a date to be fixed. Yes.
May I please, Your Lordship, I beg to mention item 31 and 42.
Huh?
41 and 42 item.
Why, madam?
Lordship, my senior is currently out of station, so I'm planning to seek for an adjournment. It's a dental matter.
They have not filed affidavit. Respondent number 5. Have you informed the other parties?
Okay.
Have you informed the respondents?
No, Lordship.
No. Then make the prayer when the matter is called.
Make please your lordship. I filed application for impleading the two respondents, lordship.
Heard Mr. K. Mujumdar, learned counsel for the petition. Also heard Mr. A. Bachaji, learned counsel appearing, learned standing counsel, help, revenue and disaster management, appearing for the, and also Ms. M. Burman, learned government advocate. Also. A. Bachaji, appearing for respondent number 1, M. Burman, 2, 3, and 4. The present interlocutory application has been instituted for impleading the opposite party number 5 and 6 as party respondents in the connected with petition being WPC number 150/2026. Also, this court has perused the contentions raised in the present interlocutory application and finds that the opposite party that in the connected with petition reliefs have been sought for against the opposite parties number 5 and 6 and accordingly they are necessary and proper party in the proceedings of the said writ petition. So accordingly, So the prayer for impleading has also not been opposed to by the learned counsel for the respondent. Accordingly, the respondents number 5 and 6. Accordingly, the applicant is permitted to implead the respondents number 5 and opposite party number 5 and 6 as party respondents number 5 and 6 in the connected with petition, that is WPC number 150/2026. Also, with the above observations and directions, the present interlocutory application stands disposed of. So WPC लिखी हुआ है. View of the order passed today in I(C) number 839/2026, permitting the petitioners to incorporate to implead the following. Implead the following authority and individual as following individual following 1, 2. As party respondents number 4 and 5 in the present petition.
5 and 6.
5 and 6 in the present petition, comma, petitioner to file an amended cause title within 2 working days from today. On filing of such amended cause title, petitioner to take steps for service of notice upon the newly impleaded respondents number 5 and 6 by way of registered post. Registered to list this matter again after 4 weeks on a date to.
March obliged.
Yes, what is your instruction?
No, may I please, my lord, I would like to place certain communication before this honorable court. My lord,
Just show me that letter, that how you sent him out.
my lord, that particular release order is not with army officer,
It's not with the,
the army, my lord.
Why?
Because, my lord, in this case, an FIR has been filed by the father of the
you
victim.
gave that documents to the police.
Police station,
Huh?
police authority, my
You
lord.
have handed over.
Yes, my
Where
lord,
do I
probably
get
we
it?
have handed over, my
Where
lord.
do I get it?
And thereafter, my lord,
Now, where do I get it from your affidavit that you have handed over these documents to the?
no, my lord, this is a communication that I would like to place before my lord. And there are two
Ms.
communications.
Burman, have you got the records?
My lord, yes, I think it pertains to districts, my lord. Yeah,
No, you have filed an FR there.
my lord, that-
Where is that material? Why?
No.
FR was filed on.
it travels 3 districts.
2009.
They require some time. That's fine. we will make it.
My lord, may kindly come to second page, that is a communication dated 6 March 2026, my lord.
But your DSP and SSP, Tamulpur, have informed the army authorities that the entire documents has been submitted to the Gauhati High Court.
As trace out that record,
No, this is handover and unable is 2 different things.
and SP has. So I need some.
Mr. B. Deka, learned CGC, and Ms. M. Borman, learned counsel for the A. Manaf, learned counsel, heard Mr. A. Manaf, learned counsel for the petitioner. Also heard B. Deka, learned CGC, and Ms. M. Borman, learned government advocate, appearing for their respective response. Mr. Deka, learned CGC has submitted, basing on instructions received, that the documents pertaining to the detention and subsequent release by the army authorities of the husband of the petitioner is not presently available with the respondents, with the army authorities. He submits that the documents pertaining to the arrest, to the detention and release of the husband of the petitioner, however, was handed over to the police authorities in course of investigation of the criminal proceeding instituted in the matter, being Tamulpur PS case number 133 of 2000. He further submits that as per the information given to the army authorities, the documents in this connection were forwarded by the police to this court. Also, Ms. M. Borman, learned counsel, learned government advocate appearing for the police authorities, have submitted that the documents, requisite documents, including the copy of the FR submitted in the matter along with its enclosures, are being searched. However, the records have not been found. She prays that she be granted further 4 weeks' time to place on record the said documents. Full stop. Prayer accepted. Registry to list this matter again after 4 weeks on a date to be fixed by it. This is a bench 4 matter.
No, fine. Compensation related to fine.
Is that may be given, madam?
Registry to list this matter again on 23/4/2026.
23 of April, no?
The documents.
But-
Uh-huh.
My lord, I will serve her, my lord.
The communications brought on record by Ms. B. Beaumont is kept on record and marked as X for the purpose of identity. The documents brought on record by Mr. B. Deca, learned CGC, is kept on record and marked as Y for the Y Coley, Coley, COLLY, for the purpose of identification. Marked as Y Coley for the purpose of.
Deeply obliged, my lord. এক মিনিট দিন, আপনি
Authorized, madam.
Sir Shoma,
Yes, sir.
earlier you were a power of attorney holder.
Yes, sir.
Subsequently, that property wherein you were a power of attorney holder was allotted in your name.
Excellent.
Then you continued with that. Subsequently, there was a road construction,
Yes.
for which road widening, your land, the land wherein you had constructed a house
That is government land.
was also taken,
Acquired, yes.
acquired, and for which payments were made to you.
Not for land, for the Assam
house.
house and the.
Oh,
plantation.
Zirat.
Yes.
Zirat payment was made to you. Now, the ATDC authorities have taken an offense to that,
Yes,
saying that how could you have done it?
exactly.
You were just an attorney holder. You could not have done it. Now, both of you, first question, was that land wherein the house was constructed reserved for ATDC authorities?
My lord, as per my instructions, because in my reply to the SOCOS, dear SOCOS, I have stated categorically that it is not shown as a reserve for ATDC.
That's the question.
Yes, sir.
For you to come in,
Now,
the land has to be reserved for you. Now, just show me that.
Lordship, if I can take Lordship to Annexure 15, that is filed by the petitioner,
Page.
page 52, Your Lordship. Yes, Your Lordship. Okay. Lordship, this is a letter that ATDC issued to the power of attorney holder of RMD Hotels. So, Lordship, if I can read the letter, because this letter is very clear about the land in question, the question that has been put forth by this honorable court.
But Miss Barua,
Yes, Your Lordship.
when you have issued this letter,
Yes, your lordship.
he was no longer the attorney holder. The allotment was already made
Yes,
in
in my
his
name.
name
Yes, your
in
lordship.
the year 15.
Yes, your lordship.
Earlier, he was a power of attorney POA holder. So that episode is over. You gave a that wayside, I mean, Prasanti
Yes,
to
your
the petitioner on 15 or 13/8/2015. Okay.
Yes, your lordship.
Now, this is very right. We accept that. But show me that this land was given to you by the government.
Lordship, the land that was acquired, that is measuring 0.027 hectare, which is approximately 1 kotha, your lordship, which was acquired by the NHIC. So National Highway. Your lordship, the boundary wall, etc., which we have already in the
Madam,
FIR.
you just show me that this property is yours. That's all. End of the matter.
Lordship, actually what has happened is that there are certain documents which I need to file as an additional
Madam,
document,
you have
which is not in my
the basic document that the land is reserved for you.
lordship.
Because you are a government.
Yes, your lordship. Yes,
The
your yes, your
government will
lordship.
allot you land.
Lordship, for that, actually, the correct authority in this, the lordship, to answer this question, I have also taken a specific ground of non-joinder of parties, your lordship. The deputy commissioner of Bishwanath Sariali,
I'm least bothered who is there or not. You have initiated an action.
Yes, your
Right,
lordship.
ma'am? You have initiated an action.
Yes, your lordship.
What is the basis of that action? That land belongs to you. Because there is a dispute now. There is a dispute.
Yes,
that
your
this
lordship.
land, and he is very categorical in his statements. This land is beyond the land of the Tourism Development Corporation property.
Lordship, I will have to,
Where
that's a
is your statement in your affidavit that this land wherein the house was set up was yours?
Lordship, I will have to submit this document. I do not have this in my possession. I would seek instructions on this, your lordship.
Otherwise,
Lordship,
it will be a case of creating a mountain out of a molehill.
Lordship, I seek some time to file this document, your lordship, because as far as my instruction goes,
Boil down to that.
as far
To what you say.
yes, your lordship, I bow down, your lordship. Lordship, actually, there are certain documents that needs to be, which is not. I need to seek instructions from ATDC with respect to this, and then I would need a little bit of more time, lordship, to submit these documents.
Now tell me another view.
Yes, your lordship.
If the house has been demolished, that means the land on which it was standing was acquired, right?
Yes, your
Where
lordship.
you paid the amount for that acquisition.
No, your lordship. Lordship.
Then if that is your land reserved to you, why a land compensation for the land was not given to you?
Lordship, that is what has happened. What our FIR, the FIR that we have filed.
FIR is only, madam, pertaining to the payments received by him against the house.
Lordship, the house, lordship, if I take lordship to this, and which is at lordship page 37, which is the assessment report by the executive engineer PWD, which is dated 21/12/2012, your lordship, and that is page 34.
An Assam type house.
Yes, your lordship. And lordship, if lordship can see the amount is, lordship, that is at page 37.
3,40,000.
Assam type house. 3,40,442, your lordship. Finally, what is the amount of compensation, which again, he also admits, it is 7,45,163. Lordship, assuming but not admitting that this is the Assam type house.
Please, you're a state. Don't make assumptions. Make your submission on concrete proof.
Lordship, I would seek some time to submit the documents with respect. With some documents.
The matter today only interfering with your
Lordship, I just need some more time to submit some documents.
Since 2019.
I bow down,
but
your
you
lordship.
have made up such a big building here, but you don't have a foundation.
Lordship, I bow down, your lordship. Lordship, kindly give me some more time to submit certain more documents, lordship. Which documents would actually establish that the case that the FIR, etc., that I have filed against, I proceeded against this person. This person is on bail. All those things will be placed before this honorable court in a proper perspective.
Case, if this is the position, that will just fizzle out.
Lordship, actually, if lordship sees the FIR, he was also absconding. If he was so true, it was not required for him to abscond even.
Madam, I'm not giving him a clean sheet. I'm only asking you, this is a writ court. We can only go on documents.
Yes, your lordship.
We can't have your Your
Yes, Your
evidence
Lordship.
is here. Where is your material to show that, see, okay, he has taken away 7,80,000. 4 lakhs, we deem it that this is land compensation. What steps have you taken with the NHI authorities or the Kala to get that amount in your, to get that recovery process?
Lordship, I have also sent the letter. I have also sent a letter to the deputy commissioner. I have also come to know that the lot Mondols, they colluded with
Fine,
him.
you have filed an
I
FIR.
have filed an FIR against all these
Fine,
persons,
got it.
Your Lordship.
But where is the material to show that you had approached Kala saying that this land wherein the building Assam type house was standing is mine. The compensation should come to me.
Yes, Your Lordship.
Where are the, it's possible under the 2013 Act that if there is anything such that you can approach the Kala and get the matter resolved. Where is that proceeding?
Lordship, I would seek some time because I need instructions and I need to submit certain documents, Lordship, before this honorable court, which is not.
Mr. M. Sharma, Learned Counsel for the petition. With regard to the allegation leveled against him by the authorities of the Assam Tourism Development Corporation Limited, including the institution of the FIR, has submitted that while such allegations have been made, the authorities of the Assam Tourism Development Corporation have not brought on record any material to demonstrate that the land over which the petitioner had constructed an Assam type house, which was finally demolished by for the construction of the road and compensation paid to him, was allotted reserved by the government for the Assam Tourism Development Corporation Limited. So, in view of the above submission made by the Learned Counsel for the petitioner, Ms. P. Borua, Learned Counsel representing the Assam Tourism Development Corporation, prays that she be granted time. She be granted how many?
4 weeks, Your Lordship.
It's a 2019 matter, madam.
I bow down, Your Lordship. Lordship, a 3.
Till. Anyway, you will have 4 weeks. Till 21/4/2026.
Much obliged, Your Lordship.
To file, to bring on record materials in support of bring on record materials to demonstrate that the land in question belongs to the ATDC authorities and the same was duly settled, reserved for it by the government. Also, registry to list this on filing of such affidavit on or before 21/4/2026. The Learned Counsel for the petitioner is at liberty to bring on record his rejoinder thereto on or before 28/4/2026. Registry to list this matter again on 30/4/2026. Full stop. It is provided that in the event the affidavit as undertaken to be so brought on record on behalf of the Assam Tourism Development ATDC authorities is not brought on record, this court on the next date of listing shall proceed to consider the issues arising herein basing on the materials already available on record.
Much obliged, Your Lordship.
May I please, Your Lordship? May I please, Your Lordship? Matters related to the acquisition of land for construction of MNP road, Lordship. Here the respondent authorities issued a notice but without taking the due process of law. Lordship, kindly see the order dated 4/2024, Lordship, of this honorable court, Lordship, 4/2024, Lordship.
My lord,
Yes, Mr. Sharma. There is an affidavit on behalf of the circle officer on record, wherein the circle officer had categorically stated that this land is recorded in the names of the predecessors of the petitioner. However, it was made government
house land.
Why have you not paid him the compensation?
No, government, Lordship, there are 2-3 procedures for
What is the
making.
procedure you have not disclosed?
Not
We
disclosed, but
only
I'm mentioning, Lordship. They have to withdraw their right upon the plot of land That we don't want this plot of land, you can use it as a road, or that is one of the way. Second way, if they fail to make the payment of the revenue, that is also not reflected in the affidavit. But Lordship, we have received one communication dated 27th of January 2025, wherein it is written that the land was obtained by after the istafanama. Istafanama means they have
Resignation.
withdrawn. But lastly, we have it is written in view of above, the specific case records were not created, and the old istafanama etc. are not found to be available in
But
this.
in your affidavit, the circle officer has not brought it.
No. This affidavit is filed earlier, Lordship. But even then, Lordship, if
That
the
means
istafanama is not
if
with
the
us,
Istafanama was there, it should have been reflected in the affidavit.
but
It's
that
not reflected.
not reflected. We should have filed an additional affidavit. But that
Now,
istafanama,
just saying that there was an Istafanama will not do.
no, not do, Lordship, not do.
There will have to be, because
Yes,
if
they have
there was
to.
an Istafanama,
yeah,
it would be reflected in the Jamabandi.
yes,
That correction of the records, it's not.
that is not there. Istafanama is also not there. In
How
that
do
case,
you
Lordship,
resolve this?
the land has to be acquired. That is the simple law.
Yes, who are you?
My lordship, my lord, our contention is that, my lord,
Who are you?
I'm telling my lordship,
Huh?
I am the villagers, my
Oh,
lordship.
villagers.
My lordship, kindly see the annexures we have annexed, my lordship. They have filed this writ petition only with the intention to block the road, my lordship. With a malified intention, they have come, and I can prove it with some of the annexures which I have annexed, my lordship.
We'll hear it.
Kindly see annexure 10, my
We'll hear
lordship.
it if you
My
require.
lord,
We'll
from
hear it if-
10 years, my lordship, there is a road already. That road was already in existence. We have annexed
We'll
that
hear
document, my lordship.
We'll hear you when, if required. We'll hear you. Sure.
Well,
But if required.
after all these years,
But-
my lordship, we
but-
cannot move, our children cannot move, my lordship. My lord,
We
kindly
are
kindly
concerned
see
with
that
the
they have
right-
suppressed
with
some documents, my
Yeah,
lordship.
we are concerned with the.
They have suppressed some documents, my
Is the
lordship.
Istafanama on record?
My lord, see, 133 proceedings have been pending. They have not annexed anything, my lordship, there.
That
My
is
lordship,
different.
kindly see, my lordship. At least, my lord, kindly see.
Council, we agree that from the documents, that the land now is government khas land. There is no dispute on that.
And my lordship, there is no dispute that there was a road in existence, my lordship, since time memorial, my lordship.
That we have seen from.
Peoples were having easementary rights, my
Mr.
lordship.
Sharma, how to resolve this issue?
They filed the writ petition only to block the road, my lordship.
And it will remain blocked, don't worry.
There is no LA case also, Lordship.
It was
My
just
Lordship,
taken.
that cannot be,
That
Lordship.
cannot be done.
That cannot be, Lordship.
Respondent number 2 also not filed their affidavit, Lordship. That is Deputy Commissioner, Lordship.
Deputy Commissioner, the stand is the
The
circle
circle
of
officers then. Your name?
NH Lashkar.
NH Loskar. But Mr. NH Loskar, learn a council for the.
itu already কি হবো মাটি এখানে লই লব পারে নি তোমার মাটি তো লব
Comment
খালি
advocate
তুমি আইবে
appearing for the appearing for the respondents number 1, 2, and 3. And Mr. You are appearing for?
Respond number
Oh, A Bhattacharjee, respond number 1, 2 and 3, H Sharma.
4
Huh?
to 7.
Huh?
4 to 7.
4 to 7. Learned counsel appears for respondent number 4 to 7. The grievance of the petitioner in the present petition is that a patta land belonging to the petitioners and duly recorded in the name of their predecessors was subsequently converted as a government khas land for the purpose of construction of a road over the same under the minimum needs program scheme. Also, the petitioners not having been released any compensation for the said purpose for the purpose of acquisition for the purpose of for the taking over of their patta land, the petitioners have instituted the present petition. The respondent number 3, an affidavit has been filed on behalf of the respondent number 3, that is the circle officer, Tatigora Revenue Circle, And therein, it was therein in paragraph 6, the following contention was raised. Para 6, page 26. 26.
May I please place this one also, Lordship, for your Lordship's convenience?
Also, it is also contended that the manner in which the pata land of the petitioner was converted to a government caste land is not very clear. And also that there is no record of acquisition of the land and of relinquishment of right over the land by the petitioner. Also, the above contentions raised in the affidavit filed by the respondent number 3 reveals that the land of the petitioner was taken over by the respondent authorities without compensating them in any manner. Also, Mr. H. Sharma, learned government advocate appearing for the respondent number 2 and 3, has placed on record an instruction received by him from the Office of the Assistant Settlement Officer, Kathigora Revenue Cycle, wherein it is highlighted that
Your Lordship is going to dispose of this matter.
I'm going to tell you. Wherein it has been highlighted that the village road, that during the period 1988-89, the village road was constructed by the government under the MNP scheme, Upot Application Minimum Needs Program, bracketed MNP scheme, by just obtaining the Istafanama, ISTAFA NAMA, from the patadar of the land over which the road was so constructed. Also, thereafter, the said land was converted as government caste land after obtaining the approval from the Deputy Commission, Jurisdictional Deputy Commission. Also, accordingly, in terms of the projection made in the instructions furnished to Mr. H. Sharma, it is seen that it is the case of the respondents, the stand of the respondents, that the land of the petitioner was taken over basing on the Istafanama given by him for such parting of the land in question, parting of his right over the land in question. Also, in view of the above position, the respondent number 3 is directed to carry out, respondent number 2 is directed to carry out an inquiry in the matter to determine the manner in which the land of the petitioner was taken over for the purpose of construction of the road in question. In the event the respondent number 2, on making of such inquiry, comes to the conclusion that there was no process adopted for taking over the land of the petitioner, and no Istafanama was also received for the purpose from the petitioners, the Deputy Commissioner shall institute appropriate proceedings for assessing the compensation, land compensation, which would now be required to be authorized to the petitioners for the land which was taken, which for the purpose authorized to the petitioner for the land, for their patta land which was taken over from them for construction of the road in question. The above exercise we initiated and concluded by the deputy commissioner within a period of 4 weeks, 6 weeks from today.
Lordship, election is there.
Fine.
Then
2 months from today.
Lordship.
2 months from today.
Release, my lordship. From time immemorial, I have the next document.
That's why I'm
I would
asking
have-
that's why I'm asking the deputy commissioner to make an
And there
inquiry.
was road in existence, my lordship.
Okay, he's making an inquiry, he'll come back.
Status quo may be maintained, Lordship. Otherwise, Lordship.
Himself
Your clients are
use the
online.
road.
Your clients are online.
My lordship,
No, then it's okay.
my lord, they demolished the road.
Then have your seat. Electrocution. 3 months from today.
Lordship.
Register to list this matter immediately after completion of 3 months from today.
Highly obliged.
May I get back
Ah.
the instruction?
Tell us, Xerox story again. The instructions furnished by Mr. H. Sharma. Copy of the instructions furnished, placed on record by Mr. H. Sharma is kept on record and marked as acceptable.
I have only one copy.
He will
Lordship,
he'll
Lordship.
photocopy and give it.
Lordship. Much.
Photocopy to amateur packet.
Highly obliged.
You have not taken steps for rectifying the affidavit.
My lord, I'll rectify it.
We can't hear this. We are going to dismiss it now.
My lord,
How can I hear this? Who is this Roger Gogoi? Nothing.
I'll rectify it, my lord.
Rectified by Friday.
Yes.
On the prayer of Mr. Sharma, without this rectification, we will not take up this matter. You are continuing? No. No, you are continuing.
Yes.
Response number 6 is continuing.
6 is continuing.
Continue.
Despite of stay order, my lord.
Continue. We are not, Rajat Gogoi, we are not going to come in for Rajat Gogoi in case of Rajiv Gogoi. On the prayer of Mr. J. Pine, Learned, counsel for the petitioner, prays that he be granted further time till 27/3/2026 to take appropriate steps for rectification of the affidavit filed in the matter. Prayer accepted, registered to list this matter again on 30/3/2020. In the event the rectification as required is not so made, in accordance with the procedure prescribed, the present petition on the next date of listing, this court would consider to pass orders dismissing the present petition on the next date of listing.
27/3 has been given.
For the filing of the affidavit, matter on 33. You have any problem?
30 on 23.
27, he will do the needful.
30.
When 30th, any problem?
I have to say.
Take up.
No,
We will go with your convenience today.
Actually, in this case, he is also 25 years he has served. The second headmaster, he
Sir, you see your date. Give me your date.
am looking. Okay.
30/3/2026. The matter be not treated as a parted and or tied up matter with this court any further. I'm not taking bench to anymore.
Obliged. Please, your lordship, in this case, my lord, matter pertains to the contractual bail of petitioner, my lord. And the respondents have filed their affidavit, my lord. At para 6, my lord, they have para 6 of the affidavit, my lord.
6,33,000 is due to you.
My lord.
We'll direct for the payment of that amount.
Lordship, they have not impleaded a
They will not.
joinder of.
Show me, madam. From the work order that you have issued, is the Union of India in any manner involved therein?
Yes, Lordship,
Where?
but.
Show me.
No,
Show
Lordship,
me
but
from the
this
work
is, this is under FMP scheme.
Wherever scheme, that work order was issued by your executive engineer, Silchar WR division.
My lord.
It is he who has to pay, not the Union of India. Whatever you have with the Union of India, you have. We will not permit that.
Lord, let them implead, Lordship.
No, rejected.
Why it is required?
Madam, these are schemes which you have floated, which work orders which you have floated. From where you are sourcing your money is your headache, not the contractors. That You have taken the work. If you did not have money, why did you ask him to do the work? Why did you ask him to do the work?
We will pay once.
First and foremost,
Lordship.
we are not permitting this. Big contractors, big, small petty contractors, if you keep this amount hanging, how will they survive? This is basically their capital.
Exactly, my lord.
This is basically their capital. We'll not permit this. And the government does not have money. Please don't. But once you have, see, for this work, you have, okay, you want me to examine that further? You have given an administrative approval for this work, then followed by a technical sanction. Technical sanction, administrative approval. Did you mention therein, or when the work was tendered, that the money of this work amount would be subject to receipt of fund from the central government? Then? Laha. Heard Mr. I allot learned counsel for the petition. Also heard Madam Onam, learned standing counsel, Water Resources Department appearing for the respondents number for all the respondents. The petition by way of instituting the present writ petition has prayed for a direction upon the respondent authorities for releasing to him his contractual dues amounting to rupees 12,78,139. Bracketed words. For 139, which is contended to be in arrears for a long period of time. Also, as projected in the present writ petition, the petitioner, in pursuance to a process of tender initiated by the respondent authorities, was found to be the successful bidder for 5 numbers of works. The works which were allotted to the petitioner are the following. Page 6, 8way. The petitioner on completion of the formalities involved after the issuance of the allotment order to him had proceeded to undertake the execution of the said works. Also, it is projected that the petitioner had successfully completed the works in question. Also, and a part of the contractual bills as raised by the petitioner was also paid to him. However, an amount of rupees 12,78,139 being in arrears, and the same not being released by the petitioner, by the respondent authorities in spite of repeated approaches made, led the petitioner to institute the present proceedings before court. The learned counsel for the petitioner has reiterated the facts noticed herein above and has submitted that the amount involved is an admitted amount, and accordingly the petitioner cannot be denied his dues in the matter. Ms. Swanson, learned counsel appearing for the respondents have submitted that the work involved were so the works involved were so required to be executed under the Roman 12 flood management program, wherein 80% of the total estimated amount is to be borne by the Government of India, Ministry of Jal Shakti, and the balance 20% by the state government, by the water resources, department. It be 1, 3, and 4. Respond number 1, 3, 4, and 5 by the water resources department. The learned counsel submits that the money not being released. The government, the government of India's share in the said work not being released, the contractual dues of the petitioner was not being permissible to be cleared. Also, accordingly, she submits that the direction be issued to the accordingly, she submits that a direction be issued to the Ministry of Jal Shakti, Government of India, for releasing the amount involved. So I've heard the learned counsel for the parties and perused the material available on record. Against the claim made by the petition in the present petition for being released his contractual dues of amounting to rupees 12,78,139. The respondents in the Water Resources Department have filed an affidavit in the matter and therein had admitted that the petitioner had executed works amounting to rupees 11,25,624, and out of the said admitted amount, an amount of rupees 4,92,560 has already been released to him, and a balance of rupees 6,33,064 is in arrears. Also, the respondent authorities having fully admitted the entitlement of the petitioner to the extent of rupees 11,25,624, the claim made by the petitioner over and above the said amount would not be permissible to be considered by this court. This court accordingly holds that the petitioner is entitled to an amount of rupees 11,25,624 and an amount of rupees 492,560 having already been released to him. The petitioner would now be required to be released an amount of rupees 6,33,064 by the respondent authorities. Full stop. At this stage, the submission made by the learned counsel for the respondents 1, 2, 3, and 1, 3, 4, and 5 is to the extent that a direction is also required to be issued to the Government of India, Ministry of Jal Shakti, Government of India, for release of its share in the works involved. For release of its share is to be issued by this court, is to be passed by this court. Also, they said submission is noticed only to be rejected in as much as in the work orders issued, as well as in as much as this stated in the bar that in the advertisement issued advertising the works in question, inviting bids, in as much as in the tender notices issued inviting bids for the works in question, no such specification was made that the money involved therein would be permissible to be released only on the same being made available by the Ministry of Jal Shakti, Government of India. Further, in the work orders issued to the petitioner also, no such stipulation is found to have been made. Accordingly, the work being required to be executed by the petitioner by the authorities in the Water Resources Department, this court is of the considered view that the amount involved would be required to be released by the authorities in the Water Resources Department, and it would be open to the authorities in the Water Resources Department to claim the amount from the Government of India if it is so permissible. So, in view of the above conclusions reached by this court, the respondents in the Water Resources Department are directed to release to the petitioner his admitted contractual area dues of rupees 6,33,064 within a period of 3 months, 6 months from today. So, in the event the said amount is not released within the period of 6 months from today, the said amount would carry interest at a rate of at the rate of 6% per annum immediately with effect from the date 6 months has lapsed from the date the petitioner has served a certified copy of this order upon the respondents number 1, 2, 3. 1, 2, 1, 3, and 4. With the above observations and directions, the present with petition stands disposed.
Lordship, a series of the repetition was disposed of on 13/8/2025. Similar issue in Amarendra Sharma. Lordship may note that also.
Same line.
Yes, yes.
Same line.
Yes, yes.
You have not placed that judgment before me.
Yes, Lordship. I just have the citation, Lordship.
Is this judgment contrary to those judgments?
They have made Jal Shakti the party, where state and the central, they have they're part of share.
We are not possible to file an appeal here.
Obligement. May it please your lordship. This matter,
The Industries Department was supposed to get instructions today as per the last order, Lordship.
it was basically.
Yes, where is Mr. J.K. Goswami?
Today, J.K. Goswami is not available on.
Not appearing before me.
Not
Any
Not-
unauspicious day today?
No, it's for some
Yeah.
personal
Or the
difficulties.
court is unauspicious for him.
For some personal difficulties, he could not be appear before this court, Lordship.
He is not in the court today.
Yes,
I
Lordship.
thought that he does not want to appear before me. Whole thing gone. We have brought it down to a certain extent. And now, all of a sudden, he is not here. The whole exercise goes to waste.
Kindly
The
fix
only
after
thing that
2
was
weeks.
is required to bring is that whether.
Yes,
How would that post system
Yes,
was that?
because
That's
this
not
is-
only.
Normally, your lordship.
Inspection-
Because
this
your
is not a
grievance is
similar-
there.
This is not a case where your advertisement
No.
issued, you apply. This is the
Only
case.
thing you say, give me 3.
Yes.
They say that, see, we have this criteria,
Yes.
so you got 4. Fine,
That-
how
that
is that
criteria-
criteria?
That-
That much only,
That's.
procedurally.
Kindly fix in the month of April, Lordship.
Why April? Why April? We'll fix it in April 27.
Yes, Lordship.
April 27.
No.
Then?
First week of April. Otherwise.
Uh,
uh,
It is submitted that Mr. J.K. Goswami, learned additional senior government advocate, on account of certain personal inconvenience, is not present in the court. Mr. J.K. Goswami, in terms of the earlier directions, in terms of the earlier order dated 27/2/2026, was to receive instructions with regard to the query of this court as reflected therein, reflected in the said order. So, in view of the inability expressed on behalf of Mr. J.K. Goswami to appear before this court on today, registered to list this matter again on 30/3/2026. No further adjournment shall be granted in the matter, and in the event the instructions as sought for when the order dated 27/2/2026 is not placed on record on the next date of listing, this court would consider the requirement of would consider as to whether the personal appearance of the person who would be in a position, the authority who would be in a position to furnish this said instruction before this court.
Obliged, Lord.
Registered to list this matter again on 30/3/2026 for further hearing. Madam, tell him that if we don't get it, no problem. 2 o'clock we'll have whoever it is online video conference. We want this information.
On 30.
Obliged, Lord.
Obliged.
Ms. Borman, your this last annexure, that last OM or something you have brought in, seems to be contrary to the division bench judgment. That page 52, 14/12/2020.
But here, my lord, facts of the petitioner is that he has given 1 lakh already.
No, I
Now-
got it. But
Yes.
there is a division bench order on this. When there was a dispute between two
Right.
benches, matter was referred to the division bench.
My lord,
Division bench said that this is a beneficial thing.
my lord.
Deduct the 1 lakh, pay in the 2 lakhs. Now, this office memorandum seems to be in the teeth of that. Actually, respondent, water resources, some water resources case, payment of bills.
Similar orders also have been passed when.
No, but Deputy Commissioner is not denying that payment, my lord. So far.
We have processed it also.
Yes, yes,
But
because
because some 8 lakhs was only
Yes.
given, so he was not released.
even yesterday also I tried to get that information. By that time that sanction amount may reach and he may release the amount also. But that information, up-to-date information yet to be received on my part, my lord. And I have already requested the Revenue Council, my lord, so that they can get the update status, so that it helps to get the money, my lord.
I will follow this division bench order.
Lordship. Case number.
This one is.
Dhananjay Musahari to.
Lekha. Heard Mr. AFNU Mondal, AFNU Mullah, Learned Counsel for the petitioner. Also heard Mr. A. Bachaji, Learned Standing Counsel, Revenue and Disaster Management Department, also heard Ms. M. Borman, Learned Government Advocate, appearing for the respondents number 1, 3, 5, and 6. Also heard Mr. A. Bachaji, Learned Standing Counsel, Revenue and Disaster Management Department, appearing for the respondent number 2, and Mr. A. Cholia, Learned Standing Counsel, Finance Department, appearing for the respondent number 3. The petition, by way of instituting the present writ petition, has prayed for a direction upon the respondent authorities for authorizing to her lady. She is a lady.
No, my lord. Male.
The petitioner is a male.
Male.
To authorizing to him an additional ex-gratia amount of rupees 2 lakhs on account of the death occasioned to his brother on account of
Extremist killing, my lord.
on account of extremist activities. Also, the petitioner in the petition has the petitioner has projected that his brother, namely Ganesham Dahal, was killed by extremists way back in the year 2000. Also, but why should we give it to the brother when the wife is there?
My lord, now they are living, my lord, in Nepal.
Wherever it is, she'll come and collect that 2 lakhs. Also, it is further projected that in terms of the scheme in vogue, in force at the relevant point of time, an amount of rupees 1 lakh was authorized to the wife of the brother of the petitioner as ex-gratia compensation for the death of the petitioner's brother. Also, however, the said compensation amount was enhanced. Ex-gratia compensation amount was enhanced by a subsequent notification dated
22/6/04.
04. By the notification dated 22/6/2004, and the amount now payable was enhanced to ex-gratia amount payable now payable was enhanced to rupees 3 lakhs. Also,
Then my 13 notification, my lord, page 33.
Officer A to A. So, the materials brought on record reveal that the wife of the brother of the petitioner was authorized an amount of rupees 1 lakh by the respondent authorities. Also, in view of the provisions of the notification dated 29/7/2013, comma, the enhanced ex gratia amount of rupees 3 lakhs is also required to be authorized to the persons killed on account of extremist violence prior to 22/6/2024. Accordingly, on account of the death occasioning in respect of the brother of the petitioner, comma, which is also on account of which is also due to extremist violence, comma, the family of the brother of the petitioner would also be entitled to the enhanced compensation of rupees 3 lakhs. Full stop. The family of the brother of the petitioner having already been authorized rupees 1 lakh, comma, the balance amount of rupees 2 lakh is now required to be authorized to the family of the petitioner. Also, this court further finds from the affidavit filed by the respondent number 5 that a proposal for authorizing to the family of the petitioner the additional ex gratia compensation of rupees 2 lakhs was already processed. However, on account of lack of funds, the said amount could not be released to the family of the petitioner. Also, in view of the above position, comma, the respondent authorities are directed to authorize an amount of rupees 2 lakhs to the wife of the petitioner, or to the wife of the brother of the petitioner, namely Tika Maya Devi, within a period of, after carrying out requisite verification processes, in tune with the earlier release of rupees 1 lakh already, ex gratia amount of rupees 1 lakh already released to her, comma, within a period of 3 months from the date of furnishing of a certified copy of this order, before the
Deputy Commissioner, my lord.
huh?
Deputy Commissioner,
before the
West
West
before
West
the
Karbi Anglong.
Deputy Commissioner, West Karbi Anglong, Assam. That is the respondent number 5 here.
Right.
With the above observations and actions, the
My lord,
20%.
my lord, it may be difficult, my lord, for the wife of the, otherwise in
You are not entitled.
two other cases, my lord.
You are
like
not entitled.
Here, my lord, relative, third phase.
I'm
Well,
sorry,
can you
Mr. We are not doing that.
Here, relative is mentioned.
We are not doing that. It is the wife who is only when the class 1 heir is available. No, all others get excluded.
She's permanently living
We
there.
can't help it. Then the money will remain with the, if she is not interested, who are you to? What is your right to get that? You're not entitled.
Brother is also, my lord, entitled.
Brother, into the exclusion of the wife is not included. Wife
Here, my
can
lord,
give it.
in the notification, relative is
So
mentioned.
relative, we'll say wife because first amount was given to wife.
Or my lord, if necessary, video conference, they will confirm it. Some, so otherwise, my lord, she may not be able to come, my lord.
No need. The money will not be taken. Let it remain with the government. If the wife does not want the ex gratia,
What?
if she is the one who has suffered, okay.
Verbally authorized.
Okay.
Okay, my lord, it may remain.
No, we'll make it further. We'll make it further. Don't worry. Show me your dependency on your brother. You are dismissing the petition. Show me how you are dependent.
But yeah, dependent.
Show me how you are dependent. These are compensation paid, not for the death, but to the dependents. Show me how you are dependent on your brother. You are dismissing the petition. Show me how you are dependent. Show me how you are dependent. These are compensation paid, not for the death, but to the dependents. Show me how you are dependent. 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 Show me how you are dependent on your brother.
So that is not the condition as per notification.
Show me. I'm asking you, how are you dependent?
So I am not dependent now.
Then? So Mullah, let the things remain where it should remain. Don't stretch it.
Obliged.
Wala bhaiya ko ready. That could drop.
At least loss.
Show me the policy wherein the government can condone or waive the land premium.
My lord,
Any
I am
affidavit
not for
filed in any of the cases?
I am not for waiving lordship.
Oh.
My lord, our case is lordship.
Oh.
In 1959, land was allotted lordship. Cost of the land was taken by the government. My lord, loan was granted. From that loan lordship, it was debited lordship. Now again, my lord, the settlement, resettlement.
Any affidavit filed in any
Not
of the
filed.
cases? Yes, Mr. Sharma.
We have not received any instructions. Instructions, Lordship, they have made 3-4 district commissioners as party. Now the Bongaigaon is bifurcated, Lordship.
No,
We have to
this-
obtain the instructions
There
from
from
Bongaigaon.
23, you have not brought on record. What is your stand otherwise on this? You can't take a stand also.
Yes, Lordship, but regarding that premium amount, whether this honorable court is to.
That's what I'm asking.
That is the law point, Lordship. I can argue.
Argue then.
My lord, our case, once it was taken lordship.
Establish. Where do I get that?
My lord, kindly see page allotment order lordship. Page 38.
30?
38. 14, item 14. 38. This is the allotment order lordship. It was to the father of the petitioner lordship. Now, paragraph 4, clause 4, kindly see. My lord, cost of the land. Development cost of the land, including water supply, roads, etc.
Okay, where is the lawn bonds executed by you?
Bond sector, that is at page 35, so 45.
40?
45 loss. 45, my lord, clause 1. Building a house, my lord, cost of the amount taken, my lord, for building a house on the land specified in the schedule 2, thereto annexed 1,250, parcels of land 154 rupees lordship. So our case is, my lord,
just a. Okay, how did you repay this loan?
My lord, paid lordship. It was paid lordship. Subsequently, that was my lord, right of lordship. Kindly see next page 48 lordship.
This is the installment chart.
Yes, lordship.
Then how was this paid off?
My lord, it was paid lordship. Thereafter, my lord, this loan was right of lordship.
Page?
By the government.
Page?
Lordship. Page, my lord, 51, kindly see.
53.
50 lordship, 53 lordship. This is the letter lordship.
So till that day, writing off has not.
My lord, now,
occasion.
yes, since 1959, my lord, land was allotted lordship. We are, my lord, the allottees were their lordship. We are the descendants lordship. Now, yes, resettlement was, my lord, order was issued lordship, and we are.
Okay, where is that demand from you for the premium now?
My lord, that is at page 14 lordship. Sorry, Annex 14, page 62.
62.
Lordship.
No, this is a letter given by you.
Your Lordship. My Lord, 65. It is 65, Lordship.
No, where is that demand? 65.
Lordship. My Lord, rupees 38,000. Valuation of the said
How
land
many
is
people are involved here?
34,000.
How many people are involved?
Yeah, in this, my Lord, initially, my Lord, more than 66 families, Lordship.
Others, what happened?
My Lord, the other repetitions are also there, Lordship.
It's
Now
not
27.
listed. Not listed today.
Today, my Lord, listed, Lordship. And
All are together.
Some other, my Lord, are not listed, Lordship.
There are few other matters
Yes,
also.
Lordship. The petitioners, my Lord, case, once the money was, my Lord, paid and write-off is there, Lordship. So, second time we are again.
Interim assignment.
Presently, 27 families are there, Lordship.
Yes, Mr. Sharma.
Lordship, I have to get the instructions, Lordship. I have to.
23 onwards, you have not got anything. Now, there was a process in 1951-9 when they were brought in. Actually, they are refugees, they were given protection here. So the government had given them a loan, which included money for construction and for the purchase of the land. So that money, with that money, deemed to have purchased the land and constructed a house. That was waived. Whether government of Assam waived or not, it's not very clear. But the government of India, this is a government of India scheme. Money will come from the government of India. Government of India had directed for writing it out. So now, how can you ask a
Lordship, that is where I have to get the instructions.
The Learned Counsel for the petition. Mr. M.H. Ahmed, Learned Counsel for the petitioner, submits that the grievance raised in the present with petition is with regard to the demand of payment of premium for allotment of the land, the land under the possession of the petitioners. Also, it is submitted that when the petitioners, submitted that the petitioners who are admittedly refugees coming into the state from Bangladesh, who had come into the state in the year 1959 from Bangladesh, were allotted the plots of land under their possession, and which is under their possession as on date at that relevant point of time. Also, the land was so allotted at Bongaigaon Urban Housing Colony area. The Learned Counsel for the petitioner further submits that the government had facilitated the petitioners with a loan for construction of the house and also for payment of the premium for the allotment of the land in question. Also, the said loan amount was subsequently required by the government of India to be written off. Also, it is in the above background that the petitioners not being issued a pata with regard to the land allotted to them, they had approached the jurisdictional revenue, the district authorities, and it is while processing the said grievance of the petitioner that a proposal has been noted for payment of rupees 8 lakh for payment of a premium amount for further allotment of the land to the land under the possession of the petitioners, to them. Also, it is submitted by the Learned Counsel for the petitioner that the land having already been allotted to the petitioners and the premium price thereof having already been realized from the petitioners from the loan amount authorized or granted to them, comma, no further allotment would be called for in the matter to be issued. Only the patta of the land is required to be issued to the petitioner's hearing. Also, in view of the above submissions made by the learned counsel for the petitioner, Mr. H. Sharma, learned additional senior government advocate appearing for the respondents, and Mr. A. Bachaji and Mr. A. Bachaji, learned standing counsel, Revenue and Disaster Management Department, and Mr. H. Sharma, learned additional senior government advocate appearing for the state, for the other state respondents, submits that they be given time till
The election is there, that is well.
time till 27/4/2026 to complete the instructions in the matter, and
27?
27/4.
4. Let it be 5.
27/5. Election will get over on 9th. Then be who? I'm giving you a week more. Okay.
No,
On 4/5. On 4/5. 4, I'm giving you 2
the
weeks.
result will be declared. That is,
4, okay.
these persons will be
11/5. 11/5/2026. No further adjournment shall be granted in the matter to the respondents to complete the instruction, inasmuch as the present matter is pending before this court since 2023, and no affidavit in the matter has been filed.
This is a judicial order, Lordship. My lord, it is written, my lord, camp in 1959. Actually, before that, they have come, Lordship. My lord, 50s, Lordship.
Thereafter, the allotment was in the 90s.
50s, they have come, Lordship.
The allotment has been made in the year 1959.
Lordship.
Allotment is
Yes,
1959.
Lordship. Yes, Lordship. All right, Lordship.
Your right is recognized, Mr. Ahmed. It's only the question whether a fresh settlement process is.
Yes, that's all. All right, Lordship.
So kindly pass over the matter for time being, Lordship.
Mr. Chaudhary will.
Yes, please.
You can take yours. We'll hear, Mr. Yes.
May I please, Your Lord?
Mr. Madam, we are here, we'll not pass anything without hearing. Yes.
My lord, this is not a case that the BRPL has not tried to implement the ex-gratia scheme before the merger.
It's not that. It's
Before
not
the
that.
merger.
It's not that. It's not that.
So,
See, you, on the date of the merger,
yes,
you were not there.
yes,
You had retired.
yes,
So you had retired with certain package.
yes,
And that package is the liability of the IOCL to continue to, you're getting a pension.
yes,
You continue to get it. In your BRPL organization, there was a move to give you such benefits. What do you call that? Substantive retirement, SRP or SPR or something, what they call it?
SBF,
SBF, huh?
Superannuation Benefit
Benefit
Fund
Scheme. So, but that did not occasion
Yes,
till the time you were there.
yes,
It came up subsequently.
yes,
Now, the policy of the IOCL or the IU will be recognized as an employee of IOCL only from the date of amalgamation and merger,
yes.
not from a date prior to that.
No,
Prior
in
to
in
that,
that
you
case,
say
in that
that
case, I'm
76% share was with IOCL, so we are IOCL. No.
no. In that case, I'm a little bit differing, my lord, because in the year 2001, as Lordship has stated, that 74% equity has been divested in IOCL. So we are a subsidiary company from 2001. So anything.
But you are an independent company.
Maybe, but a subsidiary company, anything has to be implemented. Suppose ex-gratia or anything, we have to take the,
But
we
you
will
are
have
not
to
an
take
IOCL
the
employee.
approval from the IOCL.
Mr. Dakati, difference is that you are not an IOCL employee. You continue to be a BRPL company employee.
I understand, my lord. So basically, as a subsidiary company, if suppose the BRPL wanted to implement any ex-gratia scheme or anything,
That
then
is gone.
then
That-
we,
that
my lord,
today it's too late to say.
my lord, then without the approval of the IOCL,
The
they
matter
cannot do
had
that.
gone up to the IOCL board. The IOCL board had rejected it.
Now, now my submission is that the successor company cannot snap all its connection to the retired employees which have been taken over. And in that regard, I have a judgment also. So similar issues, my lord, it was of Assam Oil Company. The Retired Persons Association has filed this petition, my lord.
Because the communication of the IOCL authorities also brings within the fold with regard to that felicitation scheme and the ex-gratia scheme, AOL employees also.
My lord, from paragraph 1 itself, paragraph 4 is relevant, but the fact is from paragraph 1, so that will be relevant, my lord. If your lordship may allow me to read that. So in that case also, they have retired prior to the merger, my lord. These employees, they have revised the scheme in the year 1996. They have retired, these petitioners were retired prior to the merger of 1981. The revised pension scheme was introduced thereafter. Then the Honorable Supreme Court has held that, my lord.
This is on a different footing altogether. This is
Yes.
revision of pension.
My lord, yes.
They were already getting that benefit, whether they are entitled to that revision, which came into effect in 1995.
Yes.
The Supreme Court said yes. Nothing more, nothing less.
No, they have, my lord, if
For
you
me, that a scheme was introduced by the successor company here, which had got no connection to the benefits already being received by them.
my lord, may kindly peruse paragraph 3, my lord. What was the dispute basically? The respondents have disputed the claim of the petitioners. Their case is that retirees prior to 14/10/1981 were not the employees transferred to the successor company by virtue of Section 11 of the Nationalization Act. It does not cover the employees who had already retired before taking over the Assam Oil Company Limited. And from paragraph 4.
No, read it.
My lord.
Read it.
Yes. That being the position of the notification that is so modifying the scheme of 1983, revising the pensionary benefits does not apply to the petitioners. It is further averred in the counter affidavit that liability of pension and pensionary benefits of the retired employees is taken care of as provided under Section 6(1) of the Nationalization Act. It is also denied that any fund was established by the Assam Oil Company Limited or was transferred under Section 12(1) of the Nationalization Act to the central government Indian Oil Corporation for pensionary benefits of the employees retired prior to 14/10/1981. The scheme of 1973, out of which petitioners had been deriving the pensionary benefits, was for purchase of annuities from the Life Insurance Corporation for such employees before their retirement.
Mr. Degat, give me 2 minutes.
Yes.
I'm sorry, this will not apply. Because 73, there was a scheme.
Yes,
There was a fund created.
yes,
This fund under the Nationalization Act, Section 12,
yes.
was transferred to
Transferred to the new
the
company.
successor company, and accordingly, the rights and liability
My
to
lord,
pay you also was transferred.
My
and
lord,
it is in
here
that.
also,
We'll see.
all the, when merger has
Here, there
taken
is no
place,
such thing.
when merger has taken place, all the funds are shifted to the IOCL.
And you filed this case in 23.
Yes,
Whereas the scheme is much before 2010.
yes.
And the clarifications were also given to you repeatedly on that lines by the IOCL.
2018 also last communication.
Then
yes.
why did you wait till 2020?
My lord, we have been approaching, my lord, because this is not a
Okay,
case that
wait,
we have not given any.
Let Mr. Chaudhary come. I
My lord.
wanted to see whether you have any further things to dislodge my tentative plea. We'll see. Where is your affidavit?
Chief, it has filed, but I have checked just now, it is not on record. I may be provided my copy, my lord.
You have filed it.
Filed it, my lord.
You have got a copy.
I have got the copy from respondent number 2, my lord.
Yes, my lord.
Yes, my lord.
According to that, my lord, that present notification he is asking for as disaster management, that is not covered.
It's not a flood.
Because that bond is a private bond, my lord, belong to the school authorities. So that after that, there is a notification from the disaster department, my lord, which define the public place, my lord. So
2014.
that 2014 notification will be apply, my lord. And accordingly, after verification, I have make a statement in my affidavit that sanction order will be passed, my lord.
Huh?
Sanction order will be passed after verification of documentation and credentials, my lord. Within short.
It is not covered. What is the verification you are doing to?
No, that 2024, that disaster management notification, which he is seeking a relief, my lord.
It will not come under that.
No, that is related, that is amount is deferred, my lord. That is for 4 lakhs and now, which is covered that 14 notification in a public place according to that guideline notification of revenue branch, my lord. So he will get 2 lakhs, my lord, instead of 4 lakhs. This is the issue, my lord.
My lord, their affidavit, they mention
Tomorrow I am traveling somewhere in Gauhati. There are now this fountains created in public parks. I forget my age and I time bomb that, slip and fall in the water and die. Will pay my family 2 lakhs. Public place.
That notification says so, my lord.
my lord.
Time to time defined.
I also had been passed orders
Yes.
that you are not entitled.
But they have not yet
On the prayer of the learned counsel for the petitioner, registry to list this matter again after 2 weeks on a date, 2 weeks on a date to be fixed by. I'll dismiss your writ petition. They are saying they are getting it, you take it. Not coming in. Tell me, will I get 2 lakhs?
My lord.
till that existence of revenue notification, everyone will get.
I think I've discussed this point. I
Lordship,
felt that
it's
it is
high
not-
time, my lord. I have personally
it is not-
discussed with the revenue.
It was an
authorities, but
accident.
Nobody is.
In the accident cases,
getting
I
too
think
long.
I've been very consistent. I said, if you have, it's not a hit and run case, then you're not entitled to be covered by this.
My lord, kindly see
Mr.
the.
Counsel, I'm doing it for your benefit. I'll dismiss the writ petition. I'm asking you to do it somewhere else.
Obliged.
Obliged.
Anything more?
Lordship, kindly see paragraph 5 of the writ petition, Lordship. Paragraph 5, Lordship, may I read, Lordship? Due to wrong entry, that means, Lordship, my humble submission would be, Lordship, the petitioner knew that the date of birth was wrongly entered in service book, Lordship.
Who wrote the service book?
But she signed, Lordship.
Oh, she signed. What were you doing? What were you doing? You don't know. You're an engineering department. You don't know maths. You don't know maths. Don't know to calculate the date. Executive engineer is deemed to know maths better than us. Then we are allowing it. But Mr. A. Khanikar. Mr. Khanikar, anything more?
No.
No. You have received your pension with the deducted amount.
But
Pension, but the deducted amount. Where is the PPO, GPO?
I have not an expert, but I have received my.
Huh?
I have
You have
received
received. Heard Mr. A. Khanikar, learned counsel for the petitioner. Also heard Mr. A. N. Upadhyay, learned standing counsel, appearing for the
1, 5 and 6.
Irrigation department, appearing for the
Respondent number 1, 5 and 6.
I'm on recovery case. A Apik Mashik, Kisha Daniel. Appearing for the respondent number 1, 3.
No, I'm for 1, 5 and 6.
1, 5 and 6.
Yes.
Also heard Ms. M. Borman, learned government advocate, appearing for the respondent number 4.
25. Excess royalty.
Anybody for finance?
3 excess. I've seen P. Nayak outside lordship.
PNAC.
There some.
Mr. A. Cholia, learned standing counsel, finance, appears for respondent number 3 and 7.
Disposal.
Also, the petitioner in the present petition has raised a grievance with regard to recovery of an amount of rupees 7,41,114 from his pensionary benefits on account of overstay in service for the period from 30/4/2017 to 30/4/2018. Also, the petitioner was initially recruited as a stenographer on 2/8/1980 in the establishment of the respondent number 6. Also, at the time of opening of the service book of the petitioner, basing on the matriculation certificate produced in the matter by the petitioner, her date of birth came to be recorded as 30/4/1958. Also, the petitioner, on the basis of the said date of birth recorded in her service book, continued in her services and retired from her services on 30/4/2018 on reaching the age of superannuation. Also, after the petitioner had proceeded on superannuation, the pension and pensionary proposal in respect of the petitioner was prepared by the authorities in the Water Resources Department. And it is at that point of time that it was noticed by the authorities that a date of birth recorded of the petitioner in her service book as 30/4/1958 was erroneous, and actually basing on the HSLC certificate, the date of birth of the petitioner works out to 30/4/1957. Accordingly, it was held that the petitioner was required to superannuate from her services with effect from 30/4/2017 and not 30/4/2018. Also, the above being the position, the matter was further processed and the petitioner, on account of the erroneous date of birth recorded in her service book, having continued in her services for a period of around 1 year with effect from 30/4/2017 to 30/4/2018, the petitioner was held to be not entitled to draw the salaries as drawn by her during the said period, and the same was required to be so recovered. Also, accordingly, basing on the said position as accordingly, basing on the said projection, comma, the pension and the pension proposal in respect of the petitioner was submitted to the Accountant General for disbursement of the same, with a requirement that an amount of rupees 7,41,114 bracket of words be deducted from her DCRG benefits towards a recovery of the overpayment received by her on account of the payment of salary on account of the salaries received by her during the period of her overstay, with effect from 30/4/2017 to 30/4/2018. Being aggrieved, the petitioner has instituted the present petition. Also, the respondent authorities. Also, Mr. Kanikar has submitted that. Mr. Kanikar, learned counsel for the petitioner, by reiterating the facts noticed herein above, has submitted that the petitioner admittedly having worked for during the period 30/4/2017 to 30/4/2018, comma, the salaries drawn by her during this said period would not mandate to be recovered. He submits that the processing of the matter, as well as the communications issued by the respondent inter-office communications issued by the respondent authorities, it is clear that the respondents have not held the petitioner to be in any manner responsible for the erroneous recording of her date of birth in her service book at the time when it was so opened after her initial appointment in the department concerned. He submits that accordingly, in terms of the decision of the Honorable Supreme Court in the case of Rafiq Mashik bracket washerman ... the recovery as now affected from the DCRG benefits of the petitioner would not be permissible, and the said amount would be required to be reauthorized to the petitioner herein. Also, Mr. N. Upadhyay, learned counsel for the petitioner, submits that the date of birth of the petitioner was recorded in her service book by the respondent number 6 on 7/1/1981. So, the particulars of the petitioner as recorded in the service book, including her date of birth, was accepted to be correct by the petitioner by appending her signature therein. Accordingly, Mr. Upadhyay submits that in the event the date of birth was erroneously recorded, comma, the same was to the knowledge of the petitioner. However, she did not raise any objection thereto. Also, accordingly, he submits that the recovery now affected from the salary from the DCRG benefit of the petitioner would not be permissible to be refunded to her. Also, I've heard the learned counsel for the parties and peruse the material available on record. It is an admitted position that the date of birth of the petitioner was recorded in her service book as 30/4/2008. The said date of birth was so recorded basing on the disclosure made in the Code of Secondary Education Certificate, in the HSLC examination certificate of the petitioner, wherein her date was so recorded as
34.
No. Page
19, Lordship.
No.
16.
16. What is the date here? Age here?
That was issued on 1973. At that time, her age is 15
age.
years, 11 months.
Huh?
15 years, 11
As 15 years, 11 months on 1/3/1973. It is on the basis of the said age as recorded of the petitioner in her service in her HSLC certificate that the date of birth of the petitioner as 30/4/1958 was computed by the respondent authorities. Also, the petitioner herein only by way of appending her signature on the service book cannot be held to have the knowledge of a wrong date of birth being recorded in the matter when such date of birth was computed by an authority not lesser than the superintending engineer of the water resources department. Irrigation department. Also, accordingly, the contention of the learned counsel for the respondents that the petitioner had knowledge of the wrong date of birth recorded in her service book stands rejected. Also, this court notices that the petitioner had continued in her services with the date of birth as 34/1958 and basing thereon had superannuated from her services with effect from 34/2018. It is only after the superannuation of the petition when a pension proposal was being prepared, the erroneous recording of her date of birth in her service book had come to the notice of the authorities, and basing thereon, the respondent authorities had proceeded to determine an amount, proceeded to arrive at a decision that the salaries drawn by the petitioner after 34/2017 till 34/2018 would be mandated to be recovered, and accordingly, in terms of the stipulation made in this connection, the Office of the Accountant General, while authorizing the pension and pensionary benefits of the division, had proceeded to recover an amount of rupees 7,41,114 from therefrom. Also, in view of the above, in the light of the above facts, the issue arising before this court is as to whether it was permissible for the respondent authorities to have recovered the said amount from the pension and pensionary benefits of the petitioner. The said issue is no longer res integra and has been settled by the decisions of the Honorable Supreme Court in the cases of so and so, so and so, so and so. Further, applying the said decisions of the Honorable Supreme Court to the facts of the present case, this court finds that same applies with full case of the recovery effected in pension and health not any such recovery. So, and accordingly, the recovery so made stands interfered with. The respondent authorities are directed to authorize to the petitioner an amount of rupees 7,41,114 within a period of
4 months.
2 months from the date of receipt of a certified copy of this order. Also, the petitioner now having been authorized his salaries for the period 34/2017 to 34/2018, the petitioner would now be eligible to receive her pension and pensionary benefits only with effect from 1/5/2018. So, in the event the petitioner has been released her pension and pensionary benefits with effect from 1/5/2017, while authorizing to the petitioner the amount of rupees 7,41,114, the amount of pension authorized to the petitioner be adjusted, and thereafter only the balance, the amount remaining, be released to the petitioner.
Lordship, oblige.
Deep level.
You can't have the cake and eat it also.
You can.
But you did not make a prayer for that.
That was calculated on 34/2017.
That's why that will now have to be paid back. Yeah, assess I was NEL. Yes, Why the affidavit is not been filed from 24 onwards?
Lordship, as per my senior instruction, we have taken the step but yet to receive the instruction from the department.
Who is the authority who is not giving the instruction and to whom the letter was sent? Kindly ask your senior
Lordship,
to
kindly
disclose
give us
that name.
1 week,
by-
1 week time.
No,
We
today.
will file our
to-
affidavit.
No, 24 notices were issued. Revenue matters, affidavits are not coming. Why?
Issues and he's out of station now for treatment.
We are not concerned with him. We are concerned with the revenue. Why? We want to know who is not giving him instructions. When is he coming back? Tomorrow?
Day after tomorrow, I can.
Day after tomorrow. Okay.
Kindly fix.
Registry on the prayer of Mr. B. Gogoi. Registry to list this matter again on 23/3/2026, on which date Mr. Gogoi shall apprise this court as to why the affidavit in the matter was not filed for the last around 2 years when the matter is pending before this court. It is to be noted that notices in the matter was issued on 8/4/2024. Thereafter, on 10/6/2024, when the matter was listed, Mr. Gogoi had sought for further 4 weeks' time to complete his instruction in the matter. But it is seen that the respondent authorities for the around last 2 years have not furnished any information to instruction to Mr. Gogoi in the matter. The said aspect would be considered on the next date of listing after receiving the clarifications from Mr. B. Gogoi, Learned Standing Counsel, GST.
Interim may kindly be continued.
Interim order to continue till the next date of listing.
Small prayer, Lordship, if your Lordship may kindly permit, can it be taken up on the Lordship? Can it be taken up on 30th?
We are not concerned. We are not here to dispose of the matter. We are only seeing why the revenue is not filing. Because we're finding it in every case now. We want to streamline that. And if there is any problem, we want to get it redressed. That's all. Nothing to do with the merits of the case.
Highly applicable.
None appears for the petition on call. For the ends of justice, registry to list this matter again after 3 weeks on a date to be fixed by.
Lordship. They're supposed to take instruction.
Okay, they'll take instruction. Tell me, even if they take instruction, give it to you, it will be in the teeth of the Supreme Court directions. VGR land. How can it be? You're not a public body. You're a private individual. How can a VGR land be settled with you? What is that decision, Supreme Court?
Jakpal Singh.
Huh?
Jakpal Singh.
Jakpal.
2011 SCC, but Lordship, I have forgotten the page number. 396.
This one.
2011?
11 SCC. 396.
How is your land advisory committee is acting in the matter in violation of the directions of the Supreme Court?
Lordship, it cannot be. Cannot be.
Page 61, my lord. Page 61, my lord.
It cannot be. You show me your right to have VGR land.
And we have been possessing the land. Lordship.
You possess from whenever you can. VGR is VGR. It's not permissible even now to be de-reserved. It can be de-reserved for a public purpose, not for individuals. Submit proposal. Who is this deputy commissioner? Passing such orders in violation of the Supreme Court directions. You are entitled to have alternative land, no problem. Will not
Bosundhara 3 is going on, Lordship, they can very well apply.
Mr. Sharma, this matter is pending since March. You have not come up.
No,
with any-
Lordship, I received one instructions, but because of that, I do not want to place. In this regard, steps has been taken. We have received this instruction dated
On the
26
next
9.
date of listing, Mr. H. Sharma shall complete his instruction as to whether it is permissible for the respondent authorities to settle VGR land with individuals.
No,
in
the
violation.
instruction may I read just one sentence. In this, steps has been taken to identify equal quantum of land for submission of fresh de-reservation proposals from Circle Officer Morigaon.
Why de-reservation?
That is why, Lordship, I am not
Whether it
listing
is
it.
permissible to de-reserve, Mr. H. Sharma on the next date of listing shall receive instruction on the issue as to whether it is permissible for the respondent authorities to de-reserve VGR land for allotment of the same in favor of private individuals in violation of the directions passed by the Supreme Court of India in the case of Jakpal Singh versus State of Punjab and others, reported in 2011, 11 SCC 396, registered to list this matter again on 20/4/2026.
Let it be again same May, Lordship.
27/4/2026.
Let it be after 5th of May.
No. They are not doing anything. That time there is it will be the ballot will be
Lordship.
strong room. That will be looked after by the police.
Lordship. Lordship.
May please, Your Lordship. In item 30, Lordship, already allotment given and we have paid the premium and there are.
But they are not giving it.
Lordship, thereafter record, they filed an affidavit in opposition saying that, Lordship, some lands are in the name of the petitioner, Lordship. Page 24 and 25.
Is it a correct fact?
Lordship, they have not enclosed any document.
Forget it. You know
Lordship,
whether it is a correct fact or not.
For that, I have to take instruction.
Who
Lordship.
prevented you from taking instruction?
For that, Lordship, I will file reply.
No, nobody prevented you from taking instruction.
Lordship.
And if this is correct fact, then you have suppressed.
Lordship,
Then you have suppressed.
No, Lordship.
If it is wrong, fine, no issue. There
Lordship.
may be 100 Abdul buttons available.
Lordship.
But madam, if it is a correct fact,
Lordship, land.
then this court will come down heavily.
Land Advisory Committee.
And what are
Lordship,
the earlier round of litigations disposed of matters listed along with this? 2913, 2328. Files are 9, no? File is anything. 9, file 9.
I am not the engaged counsel, Lordship.
Huh?
I am not the engaged counsel in this.
Some cases have been listed along with this.
Person?
What is it? Some reason.
Everything else.
2350. Amjad Ali and 102 others.
Item 30 and 31 are connected. On some disposed of cases, 2913, Lordship. You have not made any prayer, Lordship. I have no idea about those cases. Online marriage on elders.
Where is this block? Where is the area?
Lordship, that is Gauripur Circle.
Gauripur, sir.
Thubri, my lord.
Dhubri
Dhubri.
district.
Not suburb.
No, Lordship.
No.
And Lordship, there is a list of beneficiary, 38 persons name included.
Okay, madam, you file your affidavit, no problem.
Yes, Lordship.
But otherwise, the petitioner in the present writ petition by projecting himself, petitioner by projecting himself to be a landless person had approached the respondent authorities for allotment of a plot of land in his favor. Accordingly, the respondent authorities had proposed to settle in favor of the petitioner a plot of land measuring 2 katha 10 lessa. The petitioner projects that the premium amount as required to be paid for the allotment of the said land was also remitted by him. However, the respondent authorities having not issued the patta in the matter to the petitioner, the present writ petition has been instituted. In the present writ petition also, the petition has made repeated contentions that he is a landless indigenous person and has been residing in the land which is now being proposed to be allotted to him for the last around 46 years. Also, an affidavit has been filed on behalf of the District Commissioner, Dhubri, Wherein?
Para 6.
It has been brought on record that after a field verification was carried out, the petitioner is found to be the recorded owner of at least a recorded owner of a plot of land measuring 12 bigha 4 katha 6 lesser, covered by DAG number 13 and Patta number 82 of village Dalsing Gerala
Dalsinger Alga.
Darsinger Alga Part 2, comma, land measuring 4 bigha 3 katha 7 lesser, bearing DAG number 25 and Patta number 193 of same village, Part 2.
There are some co-pattadars also, Lordship. They stated that Abdul Baten Akan and
We are coming to that. And land measuring
4 bigha 3
4
quarters.
4 katha.
4 bigha, madam.
Where?
4 katha.
4 katha.
Land
2
measuring.
lesser maybe. Cannot be 21 lesser.
Lordship, 2 lesser.
2 lesser.
2 lesser.
That is 2 lesser.
DAG be covered by DAG number 33 or Patta number 7 of same village, comma, land measuring 3 katha 19 lesser, bearing DAG number 34 and Patta number 194 of village same. Land measuring 1 bigha 3 katha 11 lesser, covered by DAG number, covered by DAG number 174, Patta number 190 of so and so. Land measuring 1 bigha 3 katha 0 lesser. To me, I come kora. It a code area, my taking. Wherein in paragraph 6, the details of the land possessed by the petitioner as its pattada has been brought on record. The contentions made in paragraph 6 being relevant is extracted here in page 24, 25, para 6 to pura kodi. So a perusal of the contentions made by the respondent number 3 in para 6 would reveal that the projection made by the petitioner in the present writ petition that he is a landless indigenous person is clearly a misrepresentation. Ms. R. Chaudhary, learned counsel for the respondent, submits that she be granted a week's time to file an affidavit in the matter, to file a rejoinder to the said affidavit filed by the respondent number 3. Pray accepted. Registry to list this matter again on 27/3/2026.
And in item 31, Lordship, records are already corrected, only Patta.
Patta was, yes, why the Patta is not issued?
My lord, that is instruction is awaited, madam.
Okay. Along with WPC number 3790/2025.
No, my lord, let it be this after BU, my lord.
No.
It's a case of 25, my lord.
Let it be together.
Together it will be again. my lord.
If we'll, that day you make your prayer, we'll segregate it. But today let it be together. A WPC 2169/2025 list along with WPC.
This is 3790, Lordship.
3790/2025.
Then my lord,
along with Tokyo, I said. Oh, along with us. 3771. Oh, sorry. WPC 3790/2025. List along with 3771/2025. Aru tuk jitu order issue mo itu hol 3771/2025. List along with 3790/2025.
3790, Lordship, instruction is awaited, Lordship.
27 or 27/3?
27/3.
Lordship, 27/3. Both the matters.
Both the matters.
Some time may be given as they have not given any documents, Lordship. We have to obtain the certificate.
Abe, you know whether you have those documents. Deny it.
Lordship.
Then we can ask. If you have land, madam, in your name, you know.
Maybe his other brothers, maybe their lordship.
But
too.
Abdul Batten, they have made such categorical statement, you will have to counter that. And if not, you will have to say these lands are not mine.
If it is
Then we
strict-
will ask them to bring in details. And if that details come in, then it will be cost.
Lordship,
Then I'll make it part-1. Then
lordship,
it will be
approval
cost.
was given during approval, they have verified.
Okay,
lordship.
forget it. Forget it. We'll see. But the very
Lordship.
categorical statement has come on. We can't ignore that. You get your reply.
30th of March, lordship.
3-0. ठीक है sir. 3-0.
Applies, lordship.
Yes, Mr. Day.
If 31, my lord, if in the matter with regard to the, my lord, the next 30, if instruction is, it's a very short time election process, then at least my lord will.
We are not we don't want any instructions on that. We only want instructions in for her to file an affidavit in 30.
Next
31, we will not do anything. Remind me if it comes before.
Lordship, in these matters, Mr. S. Bhattakur will advance arguments on behalf of the petitioner's lordship. He is on legs in court 5, Lordship.
On the prayer of the learned counsel for the petitioner, a registry to list this matter again after 2 weeks on a date to be fixed by date. They will not be possible.
If I may pray for a fixed date, my lord.
2 weeks, okay.
Any date. We are
1/4/2026.
1/4, my lord. I'm so obliged.
There is an interim order.
Interim order passed earlier to continue till the next date of listing.
Much obliged.
Why your reply has not been filed? Substitution.
I was out of station for some time, therefore.
Okay.
But my-
Mr. A. Bhattaji, learned counsel submits that on account of his own personal inconvenience, the affidavit in reply could not be filed and prays that the affidavit would be filed within 2 weeks. Give me a date. Would be filed on or before 6/5, 6/4? 6/4/2026. Accordingly, registry to list this matter again on 22/4/2026.
Obliged.
At the very earliest, ma'am, I'm sorry for one submission made by one of the council saying that Mr. Pikiraj is not keeping well and he took an adjournment. That was not without informing me because the instructing counsel is in Silchar. She could not say before the court. So I'm sorry for that, ma'am.
We have recorded it, signed it.
My lord, that adjournment is the all right, my lord. Only that submission which
Item number
took 37, I think, my lord. That was maybe
37, no?
no
50,
54.
54.
54. That was a
54 or 58.
Mal.
कोई नहीं बात मुना से.
Mal. That was a wrong submission made because it should not be made because she never told me because the instructed counsel is in Silchar. She could not, because of fear, she could not say before the court. And ultimately now.
Am I that demonic looking?
My lord?
Am I that demonic looking person?
In one
that they are afraid.
My lord, in one way, we are similar. My lord, I won't say because my lord, our color is something to fear about, my lord.
Lordship, item number 54 and 55, 8.
What ground should we assign?
My lord.
What is the ground that I should assign now?
My lord, that remember ground, whatever it is there, but what I want to say, my lord, the fact should not have been said that way. That was what I'm sorry
at
for.
2 o'clock, ask the council to come.
My lord, I have called her, but she is not picking up one
Ask
side.
her. No. Coercive measures would be taken, but I want to impress upon her that this is not the way it is done.
No, it's correct.
Ask her to come.
My lord, I will inform her.
Okay.
My lord, here is this case, my lord. A notice was issued. That notices are from page.
You have already been evicted.
My lord. Notices were from page.
Okay, what is your case? What is the nature of your occupation of that?
We have
when have you
government
been occupying?
notice. Your lordship will find the notices at 157.
No. From when were you occupying those lands?
My whole issue is that, my lord.
We'll come to that.
But what is the long durations we are there?
From when? There has to be a starting point somewhere.
My lord.
What is
if your lordship will find that in the paragraphs we have said, my lord, from the paragraph number 1 onwards, your lordship will find that we have for 55 years, for more than 55 years, para 5.
So 55 years would be
Malad.
from 2025.
Malad. And para 3, my lord, petitioner number 1 is for 40 years. Petition number 1 is for 40 years.
40 years.
Petition number 2 is for 56 years.
So
Petition number 3.
1 is from 1985. So before that, where was he?
That statement, I
No,
don't.
that has to be. Where was he? How did he come to this?
My lord, if I can,
Because now you want to say that must be settled with a
my lord,
with
my
a
permission, if your
no,
lordship.
no, Mr. Chaudhary, your case basically now is an alternative plot of land under the land policy.
Or in the alternative, if I can place.
Huh.
The statute, the regulation provides me, I have a right to have a, on the basis of adverse position. The statute provides.
That, why did you not go and file a?
I have filed for application, and without considering that, they have evicted me. So they have infringed my right.
Fine, you go ahead before the civil court and get your right.
Mala, that right, when I file an application.
Now tell me, 1985, you came there. Before 1985, where were you?
My lord, that issue is not, my lord.
Because if you because under the national law, that state land policy,
My lord,
you must be an indigenous person.
my lord,
That means someone who can trace his roots prior to 1966, or at least prior to 1970.
then, my lord, there should have been a reference to the family court, or the state should have.
That is subsequent. But now you tell me, where were you before 1980?
That instruction I have to obtain, because that is not in there, but only the years that, but my submission before his lordship is this: the moment I applied for the settlement of the caste land, your lordship judgment in Arvinda Vaishya, deciding on the basis of Salakuddin, and the Salakuddin decided that section 6C of the land and revenue regulation says section 27, you can acquire right. Section 27 provides me a right, and that bona fide right has to be decided. Your lordship has also given a stamp on that Salakuddin in Arvind Vaishya.
I may have made a mistake.
And that was a division bench judgment.
Division bench then made a mistake. We'll have a.
But that
next time we get it, we'll send it to a full bench. But now tell me, where were you prior to 85?
That instruction, I have to bring it prior.
Mr. P.K. Roy Chaudhary, learned counsel for the petition, submits that he would file an additional affidavit in the matter, bringing on record materials to demonstrate as to where the petitioners and or their predecessors were so residing prior to occupying the plot of land from wherein they have now been evicted. The said affidavit be brought on record within a period of 4 weeks from today. Registry to list this matter again after 4 weeks.
Mal.
May I plead your lordship? Lordship, in this matter, I am recently engaged.
No, I'm only having this. I think in the morning a mention was made. I assured that nothing would be done. I just wanted to see why the affidavit is not filed.
Respondent here.
Why the affidavits are not filed?
7, I think.
Mr. Talukdar, you have not filed an affidavit.
I was. We are also to file an affidavit.
Mr. S. Talukdar.
SK Talukdar.
SK Talukdar, learned counsel, appearing for the learned standing counsel, Corporation Department, and Mr. P.K. Roy Chaudhary, learned
for 5, 6.
Learned counsel, appearing for the respond number
5, 6, and 7. I think.
5, 6, and 7 submits that an affidavit on behalf of the respondents represented by them would be filed within the next 3 weeks.
My lord, I have not received the instruction yet. That
3
will be
weeks.
recorded, my
3 weeks.
I'll file, my lord.
Have you sent the copy?
I have sent, my lord, but I have
Tell
not.
me who is the authority. We'll require him. We'll ask him to come on.
No,
We'll ask him. If you're not being, they're not cooperating with
No,
you.
no.
They are preventing dispensation of justice.
I'll give a reminder, my lord.
If that submission comes
Yes.
before me,
No.
I am with the council.
I'm sorry.
I'll do the needful.
I'm sorry, my lord. I'll file it.
Within a period of 3 weeks.
4 weeks, my lord.
4 weeks.
4 weeks.
Sorry for provision of time. Did you? After being
Registry
registered to list
No,
this
no,
matter
no.
again on 2026.
So there are other private respondents, perhaps they are not represented. There are.
Service complete.
Yes, Lord.
Complete is any.
Service complete, Lord.
Leaking copies not as any.
Let me know, cover everything.
There are total, my lord, 54 private respondents.
No, 54
Uh,
not.
From 47, no?
From 6 to 6, from 6.
Kata, 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 kata. We've seen the, Mr. You have not taken steps.
Lordship, actually, yesterday I have engaged Lordship. I will check on the office.
Okay. Seen the office note dated 20/12/2025. So, which reveals that the that the petitioners have not taken steps for service of notice upon respond number 6 to 54. Also, Ms. So-and-so, learned counsel, appearing for the petitioner, submits that she has been recently engaged and accordingly prays that she be granted a week's time to take steps for service of notice upon the respondent number 6 to 54 in terms of the directions passed by this court-wide order dated 26/9/2025. So, the petitioner would now take steps for service of notice upon the respondents number 6 to 54 by way of speed post steps within a week from today. Also, the learned counsel for the respondents shall also bring on record their respective stand by way of filing affidavits before the next date of listing. Registry to list this matter again after 4 weeks on registry to list this matter again on 24/4/2026. Also, now I have reduced it, not taken steps. It was for admission, that's why I did not go into that. Madam, you take. Yeah. Yes, and as a decade. Yes, what it.
My lord. So basically, already as I have submitted, my lord.
That decision is not going to take you anywhere. That's in a different footing altogether.
So, but the scheme was introduced later on. So they were covered in that scheme. They were not covered.
You cannot be, because you have gone.
Yes.
And this scheme is something which is prospective in nature.
Yes.
Right? And that scheme itself within it has certain layers. If you can come to that scheme. And see, IOCL, with regard to that felicitation scheme, that is for recognizing services rendered to them by their employees.
Well,
now you have served on a, maybe now everything is one. Or from 2001, it was a subsidiary company, but it was not IOCL. You had served in some other company. Why?
My lord, as from 2001, as it was a subsidiary company, therefore.
Show me the law that a subsidiary company is also the company itself.
Therefore, any implementation for Ex-gratia or any benefit, then they will have to take the approval from the IOCL, my lord.
See, it is not required.
Yes.
That because IOCL will have a representative in the board itself.
Yes.
But technically, it is sent and approval is taken. That will, now you come to that scheme.
If your lordship, we will, yes, I'm coming to that. Before that, my lord, lordship may have a look at page 50. That was the proposal by the BRP.
This did not materialize. This did not materialize. See the light, because it was never approved.
Yes, that was not
now you come
that was
to
not
page
approved,
60,
but they have tried to
page,
implement that, my lord.
Now, how can we direct them to implement retrospectively?
My lord.
Now read 62. And mind you, this was of 2010.
Yes.
Now see, the issue of extending second paragraph, so-and-so, 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 employees who had superannuated prior to the introduction of so-and-so.
Yes.
Will be eligible to receive the ex-gratia amount.
Yes.
So SBF account scheme came in. You were within that SBF scheme. Because 2003, after 2003, SBF scheme of PRPL came in. Now you read the next one. Employees who were beneficiary members of so-and-so before their superannuation will also be eligible to receive ex-gratia, provided that amount is lower.
Yes.
Employees who did not join the SBF scheme of so-and-so and employees of BRPL are currently on roll, but not members would not, however, be eligible to ex-gratia.
Yes.
So these are the filters they have used.
And
What is the error?
And my lord, may I will look at the next page, my lord, because the provision of D is not here, I think. Next page, that is the original.
That you typed it out.
Yes.
This is your typing out.
Yes, yes. That was a inadvertent.
I have marked in the original only. The ex-gratia amount shall be paid as per so and so.
Yes.
Effective from 1/7 or from the date of superannuation of the employee, whichever is later. Now, this superannuation of the employee concerned can be understood from B and C.
Can be understood.
Who are the employees involved?
Yes.
Because 2010, it is a cutoff thing.
So it is a cutoff. On 2/5/2017, they have, if your lordship will look at the page 64, my lord, they have clarified it.
That has been clarified and it is 2006.
Yes.
31 term.
Yes. So by 36/2010, we have been we are getting that ex-gratia also from 1/7/2010. This is a fact, my lord.
And then what happened?
We are just seeking from parity with the IOCL from 2003 only.
Anything more, Mr.?
Nothing. The only thing is,
sorry,
you have
sir.
given
No,
them
no.
from 1/1/2007.
Actually, Milord, this was an act of compassion, Milord. That the
You are
30
continuing to give them.
Yeah, no, Ajita doesn't know. No, Milord, whatever was
that
there.
is not disclosed in the affidavit.
Yes. No, Milord, what I'm on
it
is, if your lordship should kindly take note of one thing.
Mr. Chaudhary, 1 second.
Yeah.
You are getting it from
1/7/2010, my lord.
till date.
Yes, yes. And for that, my lord, I'm not pressing the prayer 1, my lord.
But you did not make this submission on the last date. You did not make this submission on the last date.
Yes, maybe.
And what you are not pressing? 1.
Prayer 1, my lord. For setting aside that, my lord. As we have been getting, my lord.
So you want from pray
2, my lord.
2.
B.
A rejected. Then C?
Yes, C also.
C is that communication.
Yes.
Which says you are not entitled.
Yes.
But when did they give you from 1/7/2010? I did not find anywhere that you have said.
Even I don't have any instruction regarding.
Because I don't find this thing anywhere. Neither it's a news for me.
No, 1/7/25, 2005 is the date prescribed in 36 letter.
Earlier one.
Yes, earlier one.
That is for you, IOCL employees.
Yes.
And with regard to BRPL ex-employees, 1/7/2010.
10.
My lord, by...
How can you be given from in that scheme?
By
Mr. Deka, are you sure you're making this prayer or instructions?
Yes.
Show me where you have written in your petition.
No, it's not.
It is not there.
Then
it is not there. I have taken the instruction today morning itself, my lord. So
no.
It
my lord, by
because
my
come to
because
the
my
letters
lord,
written by the.
my lord, as
but if something is not there in the pleadings, how can we
Can
be
I-
taken by surprise?
I'm taken by surprise.
yes, my lord. By in page 64, my lord, it was clarified at page 60. Sorry, as page 65, it was clarified that who were retired prior to 31/12/2006 of BRPL.
Okay.
End of the day, what is the legal right?
Nothing is there. But that then we are coming. Then now tell me, you have filed this case in 2023.
Yes.
17, you get this money.
Yes.
With effect from 1/7/2010. Why was this fact not disclosed?
My lord, for that I have taken that instruction.
That is a very vital fact because you are claiming in page prayer number 1, payment of this due from 1/7/2010. granted from 1/7/2010 or from the date of superannuation of the employee, whichever is later. We had interpreted the whole documents on the premises that you are not getting it. Now, if you have been getting it,
Yes.
you should have disclosed that. Then your pair number 1A was wrongly made.
Lord, that's why I'm not pressing that prayer, my lord.
Then what remains?
Nothing is there, finished. Because if you don't press this scheme,
Yes,
if you don't press this scheme,
my lord.
1/7 quashing the so-and-so scheme
36/2010.
regarding
I'm
extending.
just asking for a parity, my
No,
lord.
no, no.
Nothing else, my lord.
Okay, Mr. Deka, you're making the things easier for me.
Yes.
And you not now write anything. You withdraw A, one page order will do. I'll say other reliefs gone. Because it is only from A that the whole thing was applied. Mr. Deka. So, Mr. Chaudhary, you have nothing to say. I'm giving you time till 2 o'clock. No, 2:30 we will come back.
My lord.
Clarify on this. Then we will pass the orders.
I'll do it.
But tentative is that we are dismissing. And if you are withdrawing A, nothing like it. Mr. Chaudhary, you need not be here.
No,
If
but-
required, we will call you.
He is not getting, otherwise why he would have made that prayer?
That's what I'm surprised today.
Because when his prayer is for parity,
I have come ready with all the facts to dictate. But now that you have brought in this spanner, I'm getting distorted now.
Even I am in, my lord.
You get it. Mr. Chaudhary, let him have.
yes,
Let him have.
deep problem.
We have changed it to personal inconvenience.
My lord, yes.
No, it's okay. It's okay. The lady, girl, be not. We have turned it to personal inconvenience.
My-
Yeah. Yes. What is your
My
instruction?
lord, I've confirmed, my lord, they are getting the ex-gratia from
Oh,
10.
Nothing is here.
Yes.
So you withdraw it. That's better.
My lord.
Mr. B. Deka, learned counsel for the petitioner, after attempting to argue the matter at some length, on instructions as submitted that he be permitted to withdraw the present petition. Mr. K. N. Chaudhary, learned senior counsel, appearing for the Indian Oil Corporation Limited respondents, does not object to the prayer made by the learned counsel for the petition. Accordingly, the present petition stands dismissed on withdrawal.
Much obliged, my lord.
45 minutes of mine gone yesterday night.
I'm sorry, my lord.
It's part and parcel.
Today morning I got the instruction, my lord.
I am appearing on behalf of respondent 10 million. I am filing the affidavit today.
You are filing it?
Yes,
Today?
today.
Yes, Mr. Singha, you have not filed a reply.
No,
You
I
have filed a reply.
I filed a reply, Lord.
This now becomes a disputed question.
No, your lord.
They say one ATM. You say one ATM.
Yes.
They say several ATM and a wine shop.
No, they say one ATM of a bank.
Bank and a
Wine shop.
wine shop.
Now the issue is that,
And you were getting messages regularly.
your lordship, it has happened within a span of 1 day. Now, I have lodged an FIR as well as I have,
Okay, fine.
there is no,
No, for me, it's not one transaction. It's several transactions.
so 4 transactions, 5 transactions in one shot. I'm sorry, in 1 day.
1 day.
Yes.
There are several transactions. And in all these transactions, you get a message. You get a message. So your phone was not hacked. Then it boils down to the ATM card. Now, ATM card is taken from your ATM card did not get stuck there.
It got stuck there. That is my plea, your lordship.
Then when did you take it out?
No, I was never given back. Let me project.
Oh,
the case.
that ATM card got stuck. Okay, got
Two
it.
things, your lordship.
Got it,
But
got it,
they have
got it.
not produced the CCTV video.
Okay,
video for-
that you have taken a plea.
Yes, your lordship. And the ATM card was never returned.
Mr. P. Hajorika, learned.
Your lordship,
Counsel.
I'll make a prayer that respondent number 7 to 9. I've lodged an FIR also with a specific direction to seize the video footage. Now, what they have done as regards my FIR, there is no affidavit from them also. 7 to 9. State government.
Yes, Mr. Buklial, what has happened? Okay, Mr. P. Hazarika, Learned Counsel for the Learned Standing Counsel, Reserve Bank of India, respondent number 10 submits that an affidavit on behalf of the respondent represented by him would be filed during the course of the day. So, the Learned Counsel for the petitioner submits that the respondents number 6, 7, 8, and 9 have also not brought on record their stand in the matter. Mr. Boklia, Learned Government Advocate, appearing for the respondent number 6, 7, and 8, 6, 7, 8, and 9 on the next date of listing, shall place on record the status of the investigation in the criminal proceeding instituted by the petitioner in the matter.
I have an affidavit, Your Lordship.
Lordship, I'm appearing for respondents 1 to 5.
1 to
5.
Fine. Learned Standing Counsel for the Learned Counsel for the respondent number 1, 2, 3, 4, and 5 is also present. In view of the above, registry to list this matter again on. We'll have it immediately after Bihus or before Bihus?
Can it be before Bihu if it's not convenient, Your Lordship? Otherwise, the
Because the last week would be basically a motion week. We'll have it on 21st, 21/4.
21.
You also bring your rejoinder? Because the ombudsman thing now, maybe he will deal with it.
Yes.
Was rejected because of delay.
Yes.
Fine. Fine.
Your Lordship, if the state is filing an affidavit regarding the status of the investigation,
Then
they can
let
bring
them-
it
let
prior to
them-
that.
No, let them bring it on record by way of a letter. That's enough. What is there for an affidavit?
I'm deeply approved.
Yes, electrocution.
Yes, my lord.
What happened? Where is the APDCL? Yes.
Yes, my lord. We have filed an appeal regarding the instruction.
Finding of the insert.
Yeah.
What happened to that?
We don't have such instruction, but the appeal has been filed.
Appeal
my
filed
lord.
by you. If you don't have, who will have?
I have by telephonic conversation, I have asked that when we have filed and what's the filing number, they are not able to provide that thing. My
That
lord.
means no appeal filed.
Appeal has been filed, my lord, this one.
Forget it. You tell me. I don't want to see. This is how hanging because of that.
Lordship may kindly, if may allows the appeal to be disposed in.
We don't know the particulars, only something you just say. If we have to direct them, we'll have to have some particulars.
Yes, my lord.
The Learned Standing Counsel, APDCL, prays that he be granted a week's time to place on record the particulars of the appeal preferred by the petitioner, by the APDCL authorities against the report of electric accident submitted by the Senior Electrical Inspector, Government of Assam, with regard to the incident leading to the death of the husband of the petitioner. Accordingly, prayer accepted, registry to list this matter again on 1/4/2024-26.
1/4.
Yes, land compensation.
And requisition, we're challenging that, Lordship. Affidavit has.
No compensation has been paid to you.
My lord,
Yes.
I have got the instruction, but compensation, that is a different aspect. But my lord, they're challenging that the it has been acquired under the
Okay,
1960.
we can proceed with that instruction itself.
No, my lord, let me place on record.
Then place it immediately. Mr. Endas, Learned Government Advocate, submits that the instructions in the matter has been received and he would be filing an affidavit on or before 1/4.
No, my lord, let it be after this election, my lord.
Why?
My lord, again, it will be filed by an DC, my lord.
What is there?
My lord,
Is 24/7 into elections? No. He'll also have to look up to the other works also. This is very important work. People are waiting.
1/4 will be too early, my lord. Then let it be after.
On 7/4/2026, by 7/4/20.
By 7/4.
By 7/4. Registry to list this matter again on 22/4/2026 for further 22/4/2026.
With an interim protection.
Interim order passed earlier to continue till the next date of this. Yes, who is appearing for the railways here? You're for the private respondent.
Respondent number 5, my lord.
Yes, why have you not brought on record your stand?
My lord,
We are supposed to consider the infant prayer today.
my lord, I require time, my lord, to file my affidavit, my lord. First day it has come, my lord. Trying today for the first time, my lord.
And all wholesale non-responsive tenders received. Wholesale. Only yours. And thereafter in the negotiation, the rate again changed.
Also, this is a complete instruction as it, my lord. But file my
Material instruction complete came? No. If that not, we can adjourn. Otherwise, moment you take a brief, you have the complete thing. That is the presumption.
sometime, my lord.
A prayer is made on behalf of the learned counsel for the petitioner for an adjournment in the matter. There is no representation on behalf of the railway respondents. Mr. G. Alap, learned counsel for the petition, for the respondent number
5, my lord.
5.
In both
Praise that he be granted. How many?
my lord.
3 weeks time to file an affidavit in the matter. Prayer accepted, register to list this matter again after 3 weeks on a date to be fixed by it. 42, same prayer.
Same, my lord. Respondent number
Same.
5, my lord.
Respondent number 5, same. Belegoda MIDV.
Oblige.
List it, 42 we list it along with WPC 1026 after. This is why I did not adjourn it, because that prayer that they want to file an affidavit, that has to come on record, madam.
May I please your lordship? Lordship, non-payment of contractual dues, lordship.
Yes.
Admitted.
Lordship, I have filed my affidavit. My Lordship, Finance Department necessary party here, my lord. On non-payment of contractual bill, Lordship, we have taken steps for release their bills.
Are you admitting the amount?
Yes.
Amount has been admitted, my lord.
Where is your admission?
That is not paragraph 5, my lord. They have stated regarding statement. May I read, my lord? Page 31.
Rupees 1,000.
This is the token money for a supplementary demand.
But where is your admission that you admit that this amount is due?
They have not mentioned anything there. You are not denying their
You are not
amount.
mentioned any.
Specific, there is no
No,
mention.
there is a specific claim that it's 20,50,000. How much have you paid him? How much have you balanced? Where are those where are those particulars?
Which annexes, Lordship, may kindly have a look that I have.
This is
annexed.
by respondent number 2. You
my
have
lord.
filed an affidavit.
Lordship.
Dr. Burwa,
Yes, Lordship. I have filed, my lord.
Register cooperative societies. Okay, Narayan Kumar, we only know him as the education. That's it, sorry. But where is that disclosure that you admit to that amount?
Lordship, the annexers, page 34, my lord. Annexer 1, my lord. Page 34, Lordship, I got it. So there is no denial on their part.
So we'll dispose it of.
Lordship.
But
Lordship,
sir,
but some time may be granted to release them. The elections are
1
coming.
hour, 2 hour. Heard, Mr.
You Ghosh, lordship.
You?
Ghosh.
Ghosh, learning counsel for the petitioner. Also heard Miss M. Deborah, learning standing counsel, Corporation Department.
For 2 and 3, my lord.
Appearing for the respondent number 1, 2, and 3.
One, Chief Secretary, my friend will appear. I'm 2 and 3.
2 and 3. Upod Lihiba. Heard Mr. H. Sharma, learned Eviction Senior Government Advocate, appearing for the respondent number 1. MD Bora, learned Standing Counsel, Corporation Department, 2 and 3.
Yeah.
The petitioner in the present proceeding has prayed for a direction upon the respondent authorities for releasing to him his contractual dues amounting to rupees 20, 50, 114. 20, 50, 114. Bracketed 20 lakhs 51,114, right? Also, the petitioner, in pursuance to a tender process, was awarded with the work of A to A, page para 3, page 4. 2 mark, huh? The petition, after completion of the due formalities and also signing the tender, signing the agreement, proceeded to execute the said work. It is contended by the petitioner that the work in question was executed to the satisfaction of the respondent authorities. Also, on completion of the work in question, the petitioner was also issued a work completion certificate by the executive engineer, PWD. Also, the work being completed and a work completion certificate being issued, a final bill in the matter was also prepared and submitted by the respondent number 4, requiring the and submitted before the respondent number 3, requiring the latter to release an amount of rupees 20,50,114 in favor of the petitioner herein. Also, the amount, the petitioner projects that the said amount being not disputed by the respondent authorities, he is entitled to receive the same. However, in spite of submission of the final bill in the matter by the authority competent to do so on 1/2/2023, the petitioner has not been released his admitted contractual dues in spite of repeated approaches made by him before the respondent authorities. Also, being agreed, the petitioner has instituted the present proceeding. The learned counsel for the petitioner has reiterated the facts by reiterating the facts noticed herein above, has submitted that the amount being the contractual dues of the petition, admitted contractual dues of the petitioner, having been not released for considerable not released in spite of lapse of considerable period of time from the date of successful completion of the work in question, this court would be pleased to direct the respondent authorities to expeditiously release the said amount to the petitioner along with interest at bank norms. Also, bank norms. Also, Ms. M.D. Bora, learned counsel for the petition, for the Standing Counsel Cooperation Department, by referring to the affidavit filed by the
Respondent number 2.
by the raised cooperative societies Assam, has submitted that the amount claimed by the petitioner as his contractual dues is admitted by the respondent, and necessary steps have been already taken for getting the sanction for the said amount, and the process is presently underway and would be completed within a short period of time. Also, accordingly, she submits that the amount being admitted, the same would be released to the petitioner on completion of the requisite administrative completed on completion of the processing required in the matter. Also, I've heard the learned counsel for the parties and peruse the materials available on record. The facts noticed herein above are not in dispute. The contractual dues claimed by the petitioner claimed by the petitioner amounting to rupees 20,50,114. So words have been admitted to by the respondent authorities, more particularly the respondents number 225, 224, 224, 223, but more particularly by the respondent number 2 and 3. The admission of the successful completion of the work by the respondent number 4 is evident from the work completion certificate issued to the petitioner hearing, which has been brought on record in the present petition. Accordingly, the said amount being accordingly, the contractual dues claimed by the petitioner being an admitted amount, and no dispute in this connection having been raised by the respondents number 2 and 3 in the affidavit filed by them, this court is of the considered view that the said amount is required to be released to the petitioner at the earliest. So, in view of the above position, the respondents number 2 and 3 are directed to 1, 2, and 3 are directed to release to the petitioner his due contractual, his admitted contractual amount, dues or amounting to rupees 20, 50, 114, huh?
Yes.
Bracket of Iman, within a period of 4 months from the
Lordship.
date of receipt of a certified copy of this order. In the event the said amount is not released within a period of 4 months from the date of release of a certified copy of this order, the said amount would carry an interest of 6% with effect from the date of lapse of 4 months from the date of receipt of the certified copy of the order till the amount is so paid.
Lordship may
to the
not
petitioner. With the above observations and directions, the present writ petition stands disposed of. Yes.
Yes, my lord.
Any problem? I'm ready to increase it. There's very low amount. High Court, very bad. 9% going.
Lordship may not.
High Court standard should be high. 9, 12, 20.
6% is sufficient, my lord.
And they said application of interest Nilihivi has been admitted to by Miss
Lordship,
Nilihivi.
I have observed. No, deeply obliged.
Obliged, Lordship. Yes, Mr. Hawk.
Here, my lord, petitioner, my lord, petitioners, an amount of rupees 2,14,000, my lord, had been, my lord, fraudulently transferred to another account, my lord. On noticing that, my lord, the petitioner had immediately lodged the complaint before the branch manager as well as, my lord, the officer in charge of the concerned police station, my lord. Subsequently, that amount was held by the bank authority, my lord. Now, since the amount has already been held by the bank authority, my lord, despite of repeated request by the petitioner, my lord, that amount has not yet been released, my lord. Causing, my lord, different hardships, my lord. And, well, in fact, my lord, they have filed an affidavit, my lord, I don't know, my lord. They are taking some steps, my lord, that
They have
SDGM
said that you have to file an application before the SDGM.
Yes, my lord. From where, my lord, they have, I have also.
Yes, Mr. What is the basis of your statement at para 13 of your affidavit?
My lord, yes, my lord, your lordship kindly see, my lord, the instruction that has been submitted by learned government advocate, my lord, on the other day, my lord, which has been marked as flags X, my lord. The order dated, my lord, last order से पहले वाला order.
In fact, in last time
Lord,
cases.
by that instruction.
Just give, you have shown me something, let me apply.
My
You file an application, they say that because there is a case pending.
My lord.
Like it is would like now put taking the amount on Jimma. Little.
Yeah. My lord,
It's a Jimma petition basically. Criminal case is there.
Yes.
That has been recovered, that thing has been recovered. So if you want it, because there is a criminal angle still going, how it was done, they'll have to examine that.
My lord.
So this amount, they say that why don't you file an application before the SDGM and finish it off?
Yes.
If you have any objection, we can consider that. Huh?
But that should be considered within a short period, my lord. Otherwise, my lord.
We are not disposing of the writ petition. Mr. S. Hawk, counsel for the petitioner, submits that in terms of the contentions raised by the respondent number 1 and 2 in its affidavit, as well as the written instructions placed on record by the government advocate on 6/3/2026 in the present proceedings. The petitioner would file appropriate application before the competent court, praying for release of the said amount, which was transferred out from his account by the by criminals, and which is presently placed on a hold by the what is NCRP? NCRP?
My lord, National Cyber Crime Portal, my lord.
By the NCRP. Also. Registry to list the present matter after 4 weeks. 6 weeks. 6 weeks. The petitioner on the next date of listing shall apprise this court about the outcome of such application filed by him before the competent court, praying for release of the said amount.
Lower court, my lord, I don't know what the case number, my lord, lower court.
That you ask him, you give him the details, because that lady is advocate that.
I have to file.
Everything is there in the written instruction.
Cyber PS GD entry
Yes.
number 9/25 to write down. GD entry, Cyber PS case, GD entry number
Cyber PS GTNT number
909 dated 25/12/2025.
09 of 20.
25/12/2025. Okay.
Also, I know. It is also already there, my lord.
It's here.
Yes. Obliged.
Learned SDGM, my lord, call for a report thereafter, my lord.
I know, I have seen it. That is the this thing.
Obliged, my lord, deeply obliged.
My lord.
Yes.
My lord, the case of the petitioner, my lord, the petitioner is the patradar of some plots of land, my lord. And my lord, suddenly, my lord, recently, my lord, it is found that the name of the petitioner was deleted from the pata, and the entire pata land of the petitioner was converted to, my lord, government land, my lord, without any, my lord.
Yes, why was the land converted?
Lordship, some instruction was forwarded.
But
to
that
us.
reason why the land was considered?
That nothing is there, my lord.
But what is
Only
that
they are seeking for some more time in view of the election.
Election is far away.
And my lord.
Because of elections, they are not going to do any other work. If that is your stand, we will record it and finish it up.
Lordship, may I have a look at this?
Who is the one giving you that instruction?
And my lord, they are the copies of the Sita they have sent, but it is not legible. So he has spoken.
Mr. B.J. Talukdar, Learned Counsel for the Learned Senior Counsel, appearing for the state respondent, submit that. Learned Additional Advocate General, appearing for the state respondent, submit that. The instructions as received by him are insufficient. And he prays that the matter be taken up on. Give me a date.
After 9th, my lord.
On then it will be 20, on 24/2026 for completion of his instruction. And to apprise this court with regard to the basis, as regards the basis on which the land belonging to the petitioners were converted and made government khas land. Also, no further adjournment in the matter shall be granted. Registry to list this matter again on 20/24/2026. What 20 issue to? Yes.
So this is a challenge to the so-called notice issued to the petitioner. It's on page 25. By this so-called notice, they have suspended my registration. On an earlier occasion, they have issued this same notice. It is on page 15. And it was decided in our favor. The proceedings were dropped. So on the same set of facts, same cause of action, they have issued 2 notices.
Yes, where is Mr. Ogoy or Mr. H. Burwa? You are M. Khan.
M. Khan.
Heard Mr. M. Khan, Learned Counsel for the petitioner. there is no representation on behalf of the state, on behalf of the state respondents. For the ends of justice, registry is directed to list this matter again on 25/3/2026. The state respondents are directed to place on record their stand to the Learned State Council on the next date of listing. In the event the said stand is not brought on record, no, so registry to list this matter again on prosecution in 25 or 30 go 30/3/2026.
This is March month, we have to file our returns. It may be listed a little earlier. 25th is
Okay. 27/3/2026.
okay, sir.
My lord, on respondent number 8, notice could not be served. So, we need time for taking, step upon the notice by public publication, paper publication. And the
Is
petition,
he appearing before the Supreme Court?
yes,
Huh?
no, he's appearing, the matter
Then-
is going on,
then-
but we need some time for filing additional affidavit as well. Because he was ill, so.
Madam, you're somehow trying to evade, because if he is appearing before the Supreme Court, that means his address is that only. He has received notice there. Then
We need to file an additional affidavit on this regards, so we need some time. And the SLP also status quo was passed.
Status কি হলো?
It is status to a last status to pass করা হয়েছে।
Status symbol. এটা আনিব লাগে last word.
notices were served earlier, 16.
Yeah, but it could not be, it was not complete.
Okay, you file your affidavit. On the prayer of the Learned Council for the petitioner, registry to list this matter again after 6 weeks. The petitioner shall, on the next date of listing, bring on record the address, the present address of the unserved respondent. Mr. Chaudhary, what are you waiting for?
49.
Item number?
49.
Who is opposing you? Ms. Borua. Ms. Borua.
Yes, your lordship.
The demarcation one.
Yes.
Yes, my lord.
Somebody is in foreign,
Yes.
others are here.
Yes, my lord.
Yes, where is Mr. Sharma, demarcation
My
expert?
lord, Mr. Sharma has to satisfy Roshi that, my lord, by sprinkling some color, they can demarcate.
That's a big issue, Mr. Chaudhary. You are here, we require your assistance on that. How do we go about this? Now, if we put a barrier or something, even a milestone or even wooden planks or something, whatever it is, even a sticks,
Even
that
a
will
stick-
amount to partition.
No,
That
that
will
is,
amount to determination of the possession.
that is the, my lord, no, because the court's order is very clear. Court's order is
No,
very
no,
clear.
if you put that thing there,
My lord.
that means you have in a capacity, in a position restricting the other person to enter into that area. There may be many complications there.
No, my lord, so far as the possession is concerned, my lord, whoever may be in possession of the identified
No,
land.
Hence, you have to go before the concerned court for the exact partition to be carried out in meets and bounds. But what is the purpose of this
My lord, partition has already been done.
done?
It's
Then what
only-
is left now?
Only for, my lord, the demarcation, my lord.
Sorry,
Demarcation
the
for-
demarcation. Now, the demarcation, if both the parties agree, then they can put some visible signs there.
Oh, now
But
he-
if there is a dispute, what will the Mr. Sharma,
No,
poor
my
Mr.
lord, let
Sharma?
us look at it from another
Ah,
angle, my
ah.
lord. If, my lord, there is no identification of the boundary.
That is what my first question on the first day was. If you don't do it in a visible manner, what is the point in doing?
Exactly, my lord.
Just going to the place and saying, Mr. Chaudhary, this is yours, Ms. Borua, this is yours. Moment that man goes back, that is not there. So what is the purpose of this demarcation? But I have found orders of this court wherein this court has restrained the respondents from putting on the
Yes.
land any visible marks.
What I have found, Lordship, when there is no dispute between two neighbors,
Then it is
then this demarcation works.
Otherwise, this is
Otherwise
not
not.
going to
Lordship.
work,
That
Mr.
is that I have found.
Because you say that you have to put marks.
Something. to
She will
identify.
vehemently object to that. And this is not for this court to adjudicate.
My lord, in this.
Because I'm not looking into that matter.
My lord, in this petition, my lord, your lordship needs to, my lord, confine your lordship to the, my lord, order that has been passed in the writ petition.
No, we'll also have to look into whether that is practically possible to,
No,
because
whether,
that's
my
one
lord,
of the,
that order has attained finality, my lord.
no. Whether it is practicably possible to implement. Because we had, I
That-
think after
that-
this
that-
matter
that
had come
could-
to me,
That can be, my lord, agitated in an appeal. No appeal has been filed.
No, I can, means, this matter, after it came to me, we had again directed for Mr. Sharma had undertaken a second. In spite of objection of Ms. Burwa, we have done it.
Yes.
Let us see the order.
That is why this word "so" is specifically mentioned in that orders. Order is at page 13 of the, starts from page 13.
Order today.
The relevant portion is at page 14, paragraph 5.
Contemporation.
They have shown you the respective boundaries. That's
Yes,
the end of the matter.
That can be done, not
So,
beyond that.
What more? You
That's
said I
because
have to
Lordship,
confine
on
to
that
this.
date,
If I have to confine to para 5, they have shown you.
as because on that date I was
Right,
present in
very
that
good.
court, Lordship, that this question arose and this court says, no, you cannot, just so. That is why I am just confidently arguing
have
this matter before your Lordship.
Now, whatever happens in the writ court, have you filed an affidavit, Mr. Sharma, here?
Yes, Lordship, two affidavits.
Latest one is?
Latest one is filed on 19/12/2025, pursuant to your Lordship's that observations.
26, there's a reply affidavit. Okay.
This is filed on 19/12. Starts from page 26. As your Lordship's got it.
Mr. Chaudhary, means this is a query which is troubling me as to how the demarcation when two persons are not agreeing. They cannot be forceful because there is a criminal proceeding altogether pending. What should be the middle way? Can you just
Let me
think?
Let me
Because, because I can close this matter saying that the land is shown. That is not the solution. There has to be, this order has to be given some meaning. But to what extent can this court go? Mr. Chaudhary. But the Illinois Council for the Parties also has prayed for registry to list this matter again on, can it be on 1st
April, my lord.
1st April? Not for April Fool, but April.
Much older.
1/4/2026. Mr. Chaudhary, I'm getting this matters. Whenever I'm sitting in bench 4 and 5, it's coming rapidly. Now, there are orders of this court also, wherein this marking system has been said, don't do it. But there are other orders also, wherein it says that the demarcation has to be done in meets and bounds in terms of the partition already arrived at. So I'm in a Kindly.
Had there been a specific order from the civil court, lordship, we would have erected wall also, lordship, in that
You
case.
don't erect wall, that much
No,
money you don't have.
We can go to that
money you
much.
don't have.
No,
You
no,
can
there
fill
is
those posts.
there is a specific order from the civil court. I'll place all those, my lord, before your lordship.
Means in addition to this matter, the position has to, how this court has to approach, kindly, both of you, Ms. Borua, and kindly apprise this court if I'm there.
Right.
Thank you.
Much obliged.
Much obliged, sir.
My dear lordship. Lordship, as per Loazima Court order dated 4/2/2026, lordship, service is completed.
See the lower court order dated 4/2/2026, which reveals that the service of notice upon all the respondents number 1, 2, 3, and 4 is complete. Accordingly, registry to list this matter for admissions after 3 weeks.
Beautiful.
You are appearing for
B Chaudhary, my lord, 3 and 4.
who?
B Chaudhary, ONGC.
Respondent.
Yes, respondent.
Which respondent?
ONGC. 3 and 4.
What's up? 3 weeks, huh?
Habit.
Yes, Mr. Ahmed.
I have taken steps,
Hmm.
respondent 6, 4, 5 and 6 and
Huh?
respondent 7, I collected a new address.
Okay.
Malada better, Illusion may dispose of the matter.
Hmm.
Factoring that there is due civil to have the both the parties and take a decisions because they have constructed building by violation of the if you lost it.
That is not the court's order. We are here to adjudicate. You adjudicate, we come to a conclusion, then if required, we will send it. But just post office, I'm not interested. On the prayer of Mr. J. Ahmed,
Whatever pass, I may be allowed to correct the address of the respondent 7. and take it
J.
to
Ahmed
the
submits
system.
that he would file an interlocutory application for correction of the address of the respondent number 7. Post office.
I'm appearing for respondent number 2 and 6.
Where is your affidavit?
Lordship, we have filed Wakalatnama on the date 16/3/26.
The learned counsel for the respondent number 2 and 6 also submits that she be also granted further 3 weeks time to file an affidavit in the law. So prayer accepted, registry to list this matter after 3 weeks. In the meanwhile, the petitioner may file appropriate application for correction of the address of the respondent number 7.
And I will take steps.
Array, you will have to file an affidavit application, then we pass an order. It is not that easy. Yes, Mr. Vitala.
Lordship's order dated 4/8/25, lordships.
Yes.
We are releasing the vehicle, whatever of is left. We have issued a communication. Earlier communication also is there, my lord, he's not responding. We had tried to, we issued notice to him, new notices by the authorized officer. That was also is not respond. Now we have, yesterday there was letter issued, my lord.
For what?
To come and take the Zimma of his vehicle.
Lordship, we haven't received anything.
He is giving it to you now.
Again I'm giving my lord. Because that.
Mr. D. Gogoi, give me a communication as placed on record. Communication dated 17/3/2026 issued by the Divisional Forest Officer, Eastern Assam Wildlife Division, Bokaka. That is the respondent number?
Sole respondent.
Sole respondent.
But that is the sole respondent hearing, requiring the petitioner to approach the office of the range officer, Western Range, Baguri, for taking Zimma of his vehicle. Also, a copy of the said communication has been handed over to Mr. H. Betala, learned counsel for the petitioner. Mr. H. Betala submits that he would advise the petitioner to approach the office of the range officer, Western Range, Baguri, for receiving the vehicle on Jimma. Also, in view of the above, registry to list this matter again after 4 weeks on a date to be fixed by it. A copy of the said communication dated 16/3/2026 furnished by Mr. D. Gogoi is kept on record and marked as X for the purpose of identification.
So.
You can do it. Why go the long route?
Lordship never.
Oh,
He has
now you
declared
got
your
it.
receipt,
Go.
Lordship. I'm so.
Rest we'll see what happens.
Lordship.
And go soon, because once the election thing, it will again take time. So immediately go tomorrow itself.
So then.
Otherwise, we'll think that you don't want the vehicle. You are just professing that you want the vehicle.
Lordship, several occasions we have visited this person. He is
Now
not
Mr.
handing it
Gogoi
over,
has
sir.
given you, on that I have recorded
That is
it.
great. That is great.
Yes.
Please, Lordship here, the office of Jila Anusuchi, they are taking time, asking time for some verifications, and we haven't received that verification report, Lordship. Lordship, may kindly grant us for 2 weeks time, 2 weeks more time.
Regarding issuance of caste certificate on the basis.
Caste certificate not issued.
Not issued.
Where is the order?
Page 17, Lordship.
16.
Yes, when did you submit your application?
Next month, we submitted application 26/24. But already verification done there.
Yes, what is your problem now?
Lordship
is the
here,
problem?
Lordship here, the office of Uttar Kamru, Jila Anusuchit Jita Parisa, they are seeking for verification for some times. And we haven't received that report.
DC already verified, my lord. On the basis circle officer report.
You are appearing for respondent number 3. Who is appearing
Respondent-
for respondent number 3?
Respondent number 1.
Who is appearing for respondent number 3?
Respondent number 3, nobody has.
Mr. Name?
R. Sahani.
R?
R. Sahana.
Saha.
R. Sahana. Lordship, I'll write down.
No, it's there. Item number किमान है तो?
50.
50.
R. Shahini, huh? Learned counsel appearing for the respondent number 1.
Lordship.
Submits that he be granted further 4 weeks time to place on record the compliance report in the matter.
Lordship.
To place further instructions in this. Also, the learned counsel for the petition, Mr. H. Das, learned counsel for the petitioner submits that the verification process in the matter was completed after the application was submitted in the matter by the petitioner. Also, in view of the above, the matter stands adjourned till (4/5/2026), also enabling the respondents to complete the process involved and submit the compliance report. On the next date of listing, the learned counsel for the appearing for the respondents shall place on record the compliance report towards indicating compliance of the directions passed by this court by the order dated 10/5/2024 in WPC number 2263/2020.
Hello, Lordship.
Mr. Saini, you take this back.
Now, compliance of the order, my lord, started from page 13, operative part, my lord, page 16, paragraph 6. my lord.
আপুনিও
How many respondents are there? 2.
ৰবচোন ৰব মই কেছটো কৰি লওঁ
Yes, Ms. Budler.
Yes, your lordship, lordship has already read the operative part of the order, your lordship. So it was directed to the deputy commissioner to verify and check all the records, and if the person is entitled for ex-gratia, thereafter the ex-gratia may be granted. So I've received the instructions, your lordship. There is a speaking order as well, your lordship. The claim has been rejected, your
Oh,
lordship.
very good. That is compliance.
Yes, your lordship, and thereafter, the speaking order has been copy marked to the petitioner as well. And it's being, as per as my telephonic instructions, your lordship, it is also being communicated through WhatsApp.
Where is the speaking order?
Speaking order, your lordship, next page. Next page, speaking order dated 9/12/2025.
No, this is a continuation of the, I have only 2 pages.
Sorry, your lordship, it's here. Eto didioksu.
We'll give you, if you want, you can challenge it, you challenge, give him a copy of the speaking.
Yes, your lordship. I can furnish a.
The present contempt petition was instituted, assailing, alleging violation of the directions passed by this court wide order dated 9/10/2023 in WPC number 2490/2017. While the said order, this court had granted liberty to the petitioner to approach the district commissioner of Degree by way of submitting a representation representation seeking ex-gratia payment on account of the missing of his son, who was alleged to have been kidnapped by extremists.
No, your
By
lordship.
miscreants.
No, your lordship.
But,
It's not
FIR name
fact, your lordship. The
FIR name accused person.
By the FIR, by the accused persons named in the FIR.
Yes.
it's alleged,
Also.
your lordship.
Also, this court further directed that that in the event of such application being filed, the district commissioner
Lordship, if
shall,
the the superintendent, no, the SP's report is here, your lordship. If
does it say?
they have said that they did all the investigation, your
There
lordship.
was no clue.
No
No,
clue.
but his
that
case is
person.
that I have only recorded his statement
Yes, your lordship.
that it was on the basis of the FIR. With regard to the ex-gratia compensation on account of the alleged kidnapping of his son.
Yes.
District Commissioner, but this court further directed the District Commissioner Dhubri to consider the same. And in the event the petitioner is found entitled on the basis of materials brought on record for grant of ex-gratia compensation, to forward the same to the Revenue and Disaster Management Department of Government of Assam for release of the said ex-gratia amount after further verification as may be mandated. Miss N. Bodulu, learned counsel appearing for the respondents.
2.
Respond number 2 has placed on record a speaking order dated 9/12/2025 passed by the District Commissioner Dhubri, that is the respond number 2 hearing, wherein after due inquiry, the claim of the petitioner came to be rejected. Also, this court has perused the speaking order dated 9/12/2025 and finds that the same was so issued in compliance with the directions passed by this court by the said order dated so and so. Also, in view of the above, the direction so passed is found to have been complied with. Accordingly, the present contempt petition stands closed. However, liberty is granted to the petitioner to assail the said speaking order by way of filing an appropriate application. With the close coordination of vote. Finished?
Obliged, Your Lordship.
Huh?
Lordship, that instruction is made a part of the record.
The taking order along with the instructions furnished to Miss N. Furnished by Miss N. Baudelaire. The instructions placed on record, received by Miss N. Baudelaire and placed on record before this court is and furnished to this court is placed on record marked as X for the purpose of identification. X coli. Huh? The instructions furnished by Ms. N. Baudelaire is kept on record and marked as X for the purpose of identification.
Obliged, Your Lordship.
It took ready to do that.
Lordship, in this case, order dated 11/4/2025 may kindly be seen, Lordship.
Lordship, today my senior had some personal difficulty.
That's 11/4/2025.
How is this case coming up? Registry to peruse the order dated 11/4/2025 passed in the present proceedings. And wherein in para 10, wherein in para 10, the present petition was held to be closed. Registry to take the appropriate steps in the matter after perusal of the said order dated
11/4/2025.
11/4/2025. Was there a clarification?
Subsequent order also does not reflect anything that.
How is it being listed? Let the registry see.
Lordship, obliged, Lordship.
Yes, Mojumdar.
I have taken step upon respondent number 4 and 5 by way of that stay, and I will file affidavit.
Mr. FZ Mojumdar, learned counsel for the petitioner submits that the that service of notice upon the respondent number 4 and 5 by way of dusty mode is already effected, and an affidavit in this connection would be filed by him when?
After 2 weeks.
After?
After 1 week, sir.
1 week. You have already effected service?
Yes.
1 week. Prayer accepted, registry to list this matter along with the said affidavit as and when the same is so filed.
Obliged.
Yes, Mr. Burkhaiso.
I made an application for correction of name of respondent number 4, 5. Notice was already issued. Only because of this, my lord, incorrect name of respondent number 5, we could not take steps.
You have not taken steps on 5.
Yes, my lord, only because of 5.
The heard Mr. A.K. Purkhaister and counsel for the petitioner. The present interlocutory application has been instituted, praying for correction of the name of the respondent number, opposite party number 5, in the cause title of the connected petition being WPC number 615/2026. Also, in the cause title of the connected petition, the name of the respondent number 5 has been reflected as Konika, as apostrophe means Srimati Konika, Kanika Patar, Patar. However, Mr. Purkhaister submits that her name, actual name is Srimati Konika Pathak, Pathak. Also, any objection? Mr. B.J. Talukda, learned additional advocate general appearing for the state, learned senior counsel appearing for the state respondents, submits that he would have no objection in correction of the name of the respondent number 5 as sought for by the petitioner. So, in view of the above, the name of the respondent number 5 having been inadvertently wrongly typed out in the cause list of the connected petition, this court is of the considered view that the same would be permissible to be corrected by the petitioner hearing. Accordingly, the name of the respondent number 5 as appearing in the cause title of the connected writ petition be corrected as Srimati Konika Pathak. So with the above observations and directions, the present writ petition stands disposed of. So, writ petition, in view of the order passed today in I/C number 777/2026, permitting the petitioner to correct the name of the respondent number 5 herein as Konika Pathak, Srimati Konika Pathak, the petitioner to file an amended cause title within 2 working days from today. Thereafter, the petitioner to take steps for service of notice upon the respondent number 5 in terms of the directions passed by this court-wide order dated 9/3/2026 within the next 2. Full stop. It will dispose of it.
Obliged, Lord.
May I please. Lord. This is an application for substituting the legal heirs of the petitioner under Order 22 Rule 3 of the CPC, my lord. I have stated the fact, my lord, that on 23/10.
Any objection? No. Who are you all?
And legal heirs, husband and son and daughter.
But Mr. K. Bhattacharjee, learned counsel for the petitioner. Also heard, so what number so and so, hearing for the appearing for the opposite parties. The present interlocutory application has been instituted, praying for by the legal heirs of the original petitioner, Dr. Sarifun Essa, praying for substituting themselves in place of the original petitioner, inasmuch as the original petitioner had passed on, on 23/10/2025 after filing of the present. Passed away on so and so, full stop, huh? This court, on perusal of the contentions raised in the interlocutory application, finds that the same has been so projected to be so instituted by the legal heirs of the original petitioner, late Sarifun Nessa, and accordingly the same, and further that there being a cause of action surviving the death of the original petitioner, the present legal heirs of the petitioner would be mandated to be substituted in place of the original petitioner in the connected writ petition. So the prayer for substitution has also not been objected to by the learned counsel for the respondents. So accordingly, the applicants are permitted to substitute themselves in the connected writ petition as follows. Page 3, A to A. ইয়াতে ABC দিয়া আছে BC NIDB, it 1.1, 1.21. So with the above observations and directions, the present present interlocutory application stands disposed of. Mara. In view of the order passed today in IA bracketed C number 85/2026, allowing legal heirs of the petitioners herein to substitute themselves as petitioners in the following manner. This court wide order dated this court today in IA bracketed C number 85/2020 has permitted the legal heirs of the petitioner herein to substitute themselves in place of the petitioner as follows. On the death, pura busutu. So accordingly, petitioner to the learned counsel for the petitioners to now file an amended cause title within 2 working days from today. Also, registry to list this matter again after the
On 30th March, my lord.
Huh?
30th March, because the report has come, my lord.
difficult. On 24/2024, 26.
20th,
4/2026,
the odd April, my lord.
April. Why you want it earlier?
Because report. is
Report
already-
has come.
Yes. that's
34, 33/2026.
30.
30.
Please.
May I please also? As per earlier order dated, the finance has filed affidavit today, my lord.
Huh?
Finance has filed.
Lordship, we were
affidavit today.
supposed to bring the up to date.
everything.
Yes, we were able to file it today only, Lordship.
Okay, Mr. A. Chalia, Learned Standing Counsel, Finance Department submits that an affidavit has been filed today in the matter by the respondents. Miss, you will be requiring some time,
Lordship,
file reply.
no, my lord.
Also, registry to list this matter along with the
26th, my lord.
said affidavit filed by the Finance Department on
26th,
20.
26th of this. It is already heard by your lordship with further hearing.
I'll have to hear it again.
Yes,
that's all,
Lordship,
with
there's a-
these documents
The volume in
on
the.
2/4/2026 for further hearing.
2/4.
Cool. Mullah.